Is that new? Buenas and Hafa Day. The Committee on Environment, Revenue, Taxation, and Procurement is calling this informational hearing to order. It is now 9:07 a.m. on Thursday, July 25th, 2019. The notice of this morning's informational hearing was provided to senators, stakeholders, and local media on July 17th, 2019 for the 5-day notice and July 23rd for the 48-hour notice, thus meeting the requirements of open government law. I would like to thank my colleagues who have joined me here today. To my left is Senator Therese Terlahi, and to her left is Senator William Castro. Thank you for joining me here today. The agenda for today's informational hearing is the following. To discuss per and polyfluoroalkyl substances. The first item is going to be an update by the Attorney General. Due to time constraints, we put him up on the agenda, followed by a national perspective provided by Shina Casper, who is the Vermont and New Hampshire State Director of the Toxics Action Center, and then followed by a recap and overview of PFAS, and then followed by the agency's experience and actions related to PFAS. So the intention for this informational briefing is to answer these overarching questions. What does it mean that PFAS is an emerging contaminant? How much and how long have the residents of Guam been exposed to PFAS? What are the findings of the current toxicological studies of PFAS? What steps are being taken to address PFAS contamination federally, on the state level, and locally? How would establishing a maximum contaminant level be useful in addressing PFAS contamination here on Guam? And how is this MCL, or maximum contaminant level, being determined? Is the health advisory level sufficient? What is the estimated cost of remediation if the MCL levels were lowered to non-detect to 20 parts per trillion, which tends to be the consensus from some of these states that are taking the lead? And in this uncertain regulatory setting for PFAS, what intermediate steps has GPA taken and other agencies taken to address PFAS contamination, whether it is minimizing releases, treating drinking water, or remediating contaminated sites? So we're going to begin the agenda for today with an update from the Attorney General pertaining to a recent law that was passed. So we're going to have you discuss, I know it's just been 2 weeks, but it'd be interesting to hear what you have so far. So we prepared questions for the AG. I can have you discuss it.
Sure. Thank you, Senator Perez, and good morning, Senators.
Sorry, for the record, if you can just state your name.
Yes, Attorney General Levan Camacho on behalf of the Office of the Attorney General. Our office did receive the 7 questions that you had asked us to specifically address, and the first is to discuss what the multi-district litigation process is. And there are certain kinds of cases that can be filed in federal district courts, usually if there's a diversity jurisdiction or different kinds of defendants. So what happened in this case, there were about 80 cases that had been filed across the country in multiple federal district courts. And in situations like that, there is a panel, a federal panel, the multi-district litigation panel, and they can review motions made by either a plaintiff or defendant to decide whether or not those actions should be consolidated into a single court for purposes of efficiency and consistency. The test is whether or not there are common questions of fact that would be found in all of these cases. And specific to PFAS, there was a motion made to consolidate all cases involving aqueous film-forming foams, or AFFF, which is, I'm sure, something that's going to be discussed at length, which contains PFOS and PFOA. There was a motion that was made to consolidate all those cases, or those cases into a single court, and that motion was granted, and the federal panel assigned the matter to Judge Gergel in the District of South Carolina. To be clear, the purpose of the multi-district litigation court is to handle discovery and to handle any kinds of procedural motions that would be common amongst defendants or plaintiffs. So in this case, it's expected there will probably be motions to dismiss certain classes of defendants based on things such as a contractor defense. So After those motions and discovery has been completed, then they would go back to their respective venues where the cases were originally filed, or there would be an option to choose where the venue would be litigated for trial purposes. So I'm not sure if that gives you an overview kind of what the MDL would be. The second question is whether or not or specific multi-district lawsuits that our office would be joining. And our office actually will be filing a separate complaint specific to Guam, and procedurally it would be either filed directly in the District of South Carolina, or it would be transferred there if it involves claims involving AFFF. So we would have our own complaint. It would be sent to the MDL if it does involve AFFF, and after discovery and any motions are heard, then it would potentially come back to Guam for a jury trial. The status of the RFP, we have selected a team of 6 firms, and I believe that if you haven't received a copy of it, we can go into details, but there's a Douglas and London firm, Taft firm, Kelly Dry Warren, Kennedy and Madonna LLP, SL Environmental Law Group, Levin, Papantonio, Thomas et al. And those are the 6 firms that made up a single proposal to represent Guam or to lend legal expertise to our office in the pursuit of this case on behalf of Guam. What issues and causes of action? The contract was just signed yesterday, so we haven't had a chance to speak with our attorneys about what specific causes of action Guam may file. But once we do have a copy of a complaint, we'll be sure to provide the legislature with an update. As of right now, we are working to gather as much data as we can that's publicly available that involve PFAS, the larger umbrella, and specifically AFFF, because that is what the MDL is addressing, and that was why the urgency for the special session and the law that was enacted 3 weeks ago. As far as other lawsuits that are similar in nature, there are lots of cases across over 100, I believe now, that are part of the MDL. But we'll have to meet with our attorneys and kind of talk about what specific claims that we would be filing and whether or not how much it would overlap with other existing cases. In terms of costs to the government of Guam, under the terms of the fee agreement that we negotiated, the firms will be responsible for paying all upfront costs. We will not have to pay anything. In terms of government of Guam resources, our office, part of our mission is to protect our natural resources in our environment. So we will have at least 3 or 4 attorneys that will be handling this and be involved in this litigation. But we look at that as being part of our mission and representing the government of Guam and the territory of Guam. We will do what we can to minimize. So, for example, EPA has done studies. We will be requesting those studies specific to the use of or the detection of PFAS, PFOA, PFOS. The same would go with Guam Water Work Authority, but at this point we just anticipate trying to get as much information and at that time determining whether or not any additional testing or expertise is going to be required, and that would again have to be discussed with the legal consultants. And then in terms of establishing an MCL, so I understand that the New Hampshire and Vermont individual is going to be calling in. The team that is representing Guam actually currently represents New Hampshire and New Jersey in PFAS-related litigation, so they should be very aware of the MCL and what impact it would have. But at this point, all of the claims generally sound in product liability. I don't think it would affect our ability to, what the claims would look like. It just may affect damages potentially, because if we're setting a level at 70 parts per trillion, I think that was the original bill, and then now down to 20, in terms of establishing what type of remediation we would need. If we set the baseline, wherever we set it, that's kind of what the goal would be, to get it cleaned up or to be below a certain threshold. So that would be the only potential impact that I could imagine would be at the damages stage. But we will be prepared to answer a little bit more detail once we get a little bit more information on the MCLs.
Thank you, Attorney General. I'd just like to take a moment for all that have been asked here today to provide testimony, if we can have you sworn in before questioning. So all the agencies, if you can and anybody who's here in the community who's going to testify as well. to do is Masi. So I would like to open up questions to my colleagues. Senator Therese Jalahi, if you have any questions for the Attorney General regarding his update.
Just on the upfront costs that you said the firm that you've joined with now is going to bear the upfront cost. Is Guam going to be reimbursing that in the end if we are successful?
If we are successful, then costs would be deducted prior to any award being issued.
All right, and what is their rate of compensation?
It has been set at 15% if it's pre-trial and 17.5% if after trial commences. So
Okay.
half of what was authorized by the act is
All
what.
right, that sounds great. Thank you.
Thank you, Senator Jalahi. Senator Castro? Okay. Oh, sorry, one more question.
When you said cleanup or remediation is an available remedy, are there other remedies that you foresee?
So this is where I think we're going to have to work with this team and see what types of relief that we're going to be requesting on behalf of Guam. I think some of it's going to tie into the class of defendants. So right now, although we don't know specifically what defendants we will name, the three that seem to pop up consistently in AFFF in particular are DuPont, 3M, and ChemGuard, which I believe is the first two are the makers of the PFAS umbrella, and then ChemGuard is the actual manufacturer distributor of these foams. So I don't know in terms of them being ordered to come to Guam to do any type of action here would make sense. So it seems very likely a lot of it will be monetary, but we'll have to confirm that with our team.
All right, thank you.
Okay, yeah, thank you so much for your
Thank you.
update, and we'll keep posted. I hope you can keep us posted on those
Thank you.
documents.
And Senators, I extend to you all, if you have any other questions, our office is more than happy to meet with you all and keep you abreast of what's happening as we move forward in this process.
Okay, so
Thank you.
So next on the agenda, we are inviting Shaina Casper from Vermont and New Hampshire State to provide some overview of PFAS, what's happening nationwide. So Shaina Casper, she is a director of Vermont and New Hampshire State Toxic Action Center, a New England-wide nonprofit based in Boston that organizes with communities on the front lines with local environmental and health threats. At the Toxic Action Center, she helps local community groups to clean up hazardous waste sites and promote clean water, safe energy, and zero waste. Shaina's work with the community groups has helped stop 2 pipelines, stop landfill expansions, and incinerator proposals, and more. She also facilitates the National PFAS Contamination Coalition. Shaina's organizing experience includes fossil fuel divestment, housing and economic justice, good governance, anti-water privatization, and Join for Justice Jewish Organizing Fellowship. Shaina lives in Vermont, where she enjoys her Radical Ladies Book Group and running and skiing in the Green Mountains. So thank you so much, Shaina, for making yourself available to provide some insights on what's happening nationally as far as the emerging regulatory setting. So,
Thank you for having me. Can you hear me okay?
yes, very well.
Great. Half a day. Yeah, so my name is Shaina Casper. I'm the Vermont and New Hampshire State Director of Toxic Action Center campaigns. And at Toxic Action Center, we believe that everyone has the right to breathe clean air and to drink clean water and live in a healthy community with a government that operates responsibly and democratically. We envision a
Sorry, excuse
free
me,
world.
Shaina, if you could speak slowly, I think we're getting some echo here. So just a little bit slower
or
might be
feedback.
helpful.
Great. Thanks. Sorry about that. Yeah, we envision a toxic-free world where we phase out harmful chemicals from manufacturing and where we do everything possible to clean up the toxic legacies of past mistakes. So we do this by organizing side by side with community groups fighting environmental threats in their neighborhoods. And so for over 30 years, our role has been to help first-time community activists create and execute strategies for cleaning up and preventing pollution. And nowhere has this been more important over the past years than in communities affected by PFAS. So chemical companies like DuPont and 3M have exploited loopholes in our country's safe drinking water laws for decades, meaning that most communities are not required to test for these chemicals, much less clean them up. There is no national enforceable drinking water standard for PFAS, leaving these regulations to states and communities. And these chemicals used to make everything from Gore-Tex fabric to firefighting foams, Teflon pans, other high-end coatings are highly toxic and even in extremely small concentrations have been linked to cancers and kidney disorders and reproductive disorders, immune system problems, you name it. And as I said, there is no federal drinking water standard for PFAS. And without standards, there's no requirement for communities to test for PFAS or to clean them up. And so working on the ground and in person with groups across New England, waking up to find out that the water coming out of their tap was not safe to drink and likely had not been for years, Toxic Action Center had been getting calls from communities across the country finding out that their water was also polluted. And so at a national conference in Boston in June of 2017, community leaders attended were inspired with new ideas of how to win on their local fights and wanted to collaborate and make change beyond their backyard. And so that's why we launched the National PFAS Contamination Coalition. So the National PFAS Contamination Coalition is made up of community leaders from 30 groups in 17 states and Guam who've joined together to share information, gain skills, connect with experts, and work on state and national campaigns together for real solutions and to build a collaborative and powerful force to take on big polluters. So the coalition has four main vision goals. So first, a PFAS-free world where people are not exposed to any PFAS, where poison people's health was protected, where there is justice for harms and deaths from past exposures, and where regulations change so that nothing like this can happen again. So for the past about year and a half, the campaign goal has been a 1 part per trillion maximum contaminant level, MCL, for total PFAS at the federal level.
I'm sorry,
So
excuse me, Shonda, did you say 1 parts per trillion?
1 part per trillion.
Is the
Yep,
goal.
and I'll go into that a little bit more later. Sorry?
I just wanted for everyone to hear that you said the goal is to set 1 part per trillion as the
Correct.
MCL?
Yep, correct, as the MCL. The more we learn about this family of chemicals, the more toxic we learn that it is. Even in extremely small amounts have had really significant health impacts. So, drop of PFAS in Olympic-sized swimming pools will have significant health impacts on human health and on the environment. So to protect our health, we must stop exposure. And the best way to do this is to regulate these chemicals as a class and to have a 1 part per trillion maximum contaminant level or treatment technique for total PFAS. So recently, our country's leading toxicologist, Linda Birnbaum, the head of NIEHS, said that a 0.1 part per trillion standard is what is needed to protect public health and the environment. So in this campaign, states are really leading the way. So just 6 days ago, New Hampshire passed MCL for 4 PFASs, incorporating some of this new science, showing how infants are exposed to PFAS through breast milk, with standards of 12 parts per trillion for PFOA, 15 parts per trillion for PFOS, 18 parts per trillion for PFHX, and 11 parts per trillion for PFNA. And as we've mentioned, New Jersey and Vermont and other states also have strong enforceable PFAS drinking water rules. And such protections trigger testing, which is why we need enforceable drinking water standards. We also need to be treating PFAS as a class. While we've moved away from PFOA and PFOS, the most common ones, many shorter chain chemicals are replacing these. So we must avoid regrettable substitutions as these studies are coming out showing that these shorter chain chemicals are just as bad, if not worse, than the legacy PFAS. And yet the EPA, continues to approve usage of these new generation chemicals. We don't have time to study and to treat each one in turn. We must treat these chemicals as a class. And so that's why we're calling for a 1 part per trillion maximum contaminant level or treatment technique for total PFAS. And again, we're calling for this at the federal level, but recognize that we need to lead the way at the state and the local level. So yeah, I want to see what questions you all have, and if there's any particular line that you want to go down first.
Thank you so much, Shaina. So I would like to open the floor to my colleagues for any questions. Senator Terlahi, Senator Castro.
Sorry, but I don't know if I speak on behalf of everybody, but I don't understand what she said.
Okay, we'll transcribe it. But I can probably ask some questions too. So, Shaina, can you explain how was it determined that 1 parts per trillion was the recommended MCL? Is it based on studies relating to accumulation in humans, as far as transfer through breast milk? Can you explain how that was determined, that 1 parts per trillion is what the aim is for the MCL?
In New Hampshire and in Michigan, they've been going through regulatory processes in order to determine their MCLs. And I'd encourage folks to read the NRDC and the Endocrine Disruptor Exchange study that came out earlier this year that consolidates all of the newer science that we've been seeing and comes to
Sorry,
this
excuse me, Shaina. It's hard to understand because of the echo. But so just to recap, you were saying that the studies as an endocrine disruptor, and what was the other Michigan study relating to?
It was one study that was written by the National Resources Defense Council and the Endocrine Disruptor Exchange, so NRDC and TEDx. They wrote this study that is in the Michigan. I can share it with the senators as well. But it looked at all of the different health outcomes and endpoints, looking at for infant children in utero and our most vulnerable populations. And if looking at these most vulnerable populations at these specific health outcomes, these studies basically show that there is no safe level of exposure. We can't set a maximum contaminant level for non-detect. We need to have some number. So that's why we say 1 part per trillion, because that is getting close to what we can test for. But essentially, there is no safe level of PFAS in our water. That everything has an impact on human health and the environment.
Okay, so do you know what non-detect level is as far as the sensitivity? So the testing that we have today, what is the most sensitive level that they can come down to at this point?
My understanding is that the EPA method 537.1, which is one of the most commonly used testing methods for PFAS, can get down to about 2.4 parts per trillion. However, science is changing rapidly. When I started working on PFAS just a few years ago, it was much higher. So we anticipate that as more and more communities are advocating for strong, enforceable drinking water standards that are health protective for infants, children, and our most vulnerable populations, science will find a way to test down to those levels that we are concerned about.
So what is your take about carcinogenic, they set different limits based on carcinogenic and non-carcinogenic, but if it's an endocrine disruptor, that doesn't necessarily mean it's carcinogenic, but it seems to me that when they're setting limits, they're more stricter for carcinogens than they are with the other ones. So what you're saying here today is that it doesn't have to be carcinogenic to require a lower level of an MCL.
Correct. There's a lot of health endpoints that are very concerning for human health that are linked to PFAS. So alarmingly, epidemiological studies identify the immune system as a target of PFAS toxicity. So studies have found decreased antibody response to vaccines, associations between PFAS levels and immune system hypersensitivity, such as asthma, autoimmune disorders, such as ulcerative colitis, and other significantly harmful health impacts. And it should also be noted that there are no medical interventions that will remove PFAS from the body. And as PFAS have been found in all environmental media, so not just water, but soil and food and air, PFAS have been found in nearly all of people tested in the United States. So PFAS are also found in human breast milk and umbilical cord blood, so that children are born already contaminated with PFAS.
Okay,
There's a new study that I just heard coming out.
sorry, excuse me, Shanna. Let me just interject here. So
Sorry.
you were talking about immune hypersensitivity. So
Yep.
is there a large body of evidence, or what is the evidence that shows that it's linked to, let's say, as for instance, immune disorders such as asthma and other immune-related diseases?
These are all diseases that have been, the studies have come out linked to from the Agency for Toxic Substances and Disease Registry, ATSDR. So they are by our highest federal toxicological body at the CDC.
Thank you.
Yeah.
So sorry.
And then there are plenty of other studies that haven't come out yet. So there's one that I just heard in a couple of weeks ago coming out of the University of South of Denmark, southern Denmark, that is saying that just the baseline level of PFAS that's found in people's blood is enough to impact immune function for antibody immune function from your 5-year booster shot. So there's a lot, really high levels of concern for low levels of PFAS.
So just to recap, you were saying that there is no known method to remove it from our bodies. Is that correct?
Correct. PFAS chemicals have different half-lives in our bodies. So there's lots of different numbers that you will see, but it takes between 2 and 8 years to get PFAS out of your blood, just from excreting your PFAS and as your cells turn over. And just as a comparison, BPA, which is found in plastic water bottles that a lot of, we're really concerned about, the half-life of BPA is just hours, so not years or even a decade, up to a decade.
Wow, yeah, that's pretty startling.
Yeah.
Thank you. Sorry, I was asked if you can repeat. So just to kind of recap what you said, that it takes hours for BPA, which is it's found in plastics, to be removed from the bodies, whereas in PFAS, it takes years, 2 to 8 years. Is that correct?
2 to 8 years is what I've seen. Yep.
Okay.
For different PFAS chemicals, different studies.
Okay, thank you. Sorry, I didn't mean to interrupt. You were talking some more about the effects and PFAS.
Yeah, so there's also a lot of different pathways for human exposure to PFAS, which also impacts their health impacts on the body. And again, this is where I wanted to get one of the scientists to come, and so I apologize that they weren't able to testify today, maybe another time. But that there are many, some of these different pathways into our body. PFAS can have, have many different impacts on our health. So I'm sorry, I forgot what the question was.
So I have a question. So in the pathways and how we're exposed to it, what is the determination as far as it drinking water or food sources that is the most causing the most problem?
Drinking water is definitely one of the biggest concerns in the country right now. Drinking water, according to Earth Justice, drinking water is the main pathway for PFAS, for high levels of PFAS exposure in the U.S. So PFAS enter drinking water, as you know, through firefighting foam used at military bases or commercial airports, industrial sites, runoff from leachate from wastewater treatment plants or landfills. And then when they get into a community's drinking water supply, people who are use that water source are very highly exposed for very long periods of time. And this is also particularly of concern because children drink more water per body weight than adults, and as they're developing, they have even more significant impacts from this PFAS exposure. So PFAS are present in our food supply due to leaching from packaging, fish ingesting the water, irrigating vegetables with contaminated water, and then there is also other types of exposure, through inhalation near manufacturing sites, dermal absorption through skin, but also people, particularly infants and toddlers, may ingest PFAS from hand to mouth from surfaces treated with PFAS. So picking up, crawling around on PFAS-treated carpets. But overwhelmingly, 110 million Americans are estimated to be drinking water contaminated with PFAS, and and some of these levels are extremely high, like as you know, while PFAS are virtually unregulated at the federal level, there needs to be enforceable rules to protect our families from PFAS, and this change must happen now, and particularly with drinking water.
Thank you, Shaina. So just to make it clear, there are different ways we can regulate chemicals, emerging contaminants. One is through the drinking water. Another one is the groundwater, so that's different, as well as other soil. So what is the movement nationally to set those limits as far as at what levels should a site be cleaned up? What levels for groundwater that's not made drinking water? So what are the different ways in which this chemical or these families of chemicals, how are we setting that limit, or what is the general trend nationally?
Thank you. Yeah, I've been seeing two main trends at the local and state level in order to deal with the PFAS drinking water contamination crisis. One has been through treatment techniques. So this is I should say they're both for drinking water protection. So treatment techniques are, we petitioned all 6 New England states to pass treatment technique standards to regulate drinking water to minimize public health hazards such as PFAS. So there's oftentimes broad authority under regulatory bodies to establish standard requirements for drinking water quality, treatment techniques is an enforceable procedure or level of technological performance that public water systems must follow in order to ensure control of a contaminant. The other major pathway that we've been seeing is MCL, maximum contaminant levels. And so this is where states can pass enforceable drinking water standards for PFAS, but based off of what is in the water rather than what level the treatment needs to get to. There's also, so those are both for public drinking water sources, and then there's also a movement for enforceable drinking water standards that are around for if you are not on a public water source but have a private well. So I'm not sure. I meant to look this up beforehand of what Guam's ratio of public to private water sources is. Apologies for that. But mostly I've been seeing, drinking water standards as a really effective way for states to protect their residents from PFAS chemical contamination.
Okay. Thank you so much. I would like to open the floor to my colleagues. Do you have any follow-up questions? So, thank you, Shaina, I know it's late there on the East Coast, so I appreciate you calling in.
Good evening from Vermont. Thank you for having me, and do reach out if there's any specific technical or health-related questions that I can get one of our epidemiologists or scientific experts to be able to answer for you.
Yes, definitely appreciate that. So thank you very much. So we're going to take a quick recess to reset up the cameras. To do is Masi. Ready to go? Okay, yeah, ready. We're going to start with the slides. Okay. Okay, we're back from our recess. So I would like to recap some of the basic information regarding PFAS. So we put together a presentation to give some background information. So PFAS also is known as per- and polyfluoroalkyl substances. And so they're a large family of man-made chemicals. Their general makeup is they're carbon-containing compounds, similar in the fashion of gasoline, but in place of hydrogen, they've substituted with fluorine or other side chains. So it's a family of about 4,700 compounds, and that list is growing as new chemicals are being developed. The most common ones that we've heard of is PFOS, perfluorooctane sulfonic acid, PFOA, perfluorooctanoic acid, PFHXS, which is perfluorohexane sulfonic acid, PFNA is perfluorononanoic acid. So the basic differences between this is, has to do with the size of the chemical, which is the number of carbons in them. So because chlorine and fluorine are such a strong bond, it makes that chemical very stable and persistent in the environment. So there's the difference between per and poly. So perfluoroalkyl substances are basically fully fluorinated. So all their hydrogens have been replaced with fluorine, making them very stable. The polyfluorinated substances are not fully fluorinated and can also break down. They're known as precursor substances. They can break down to the more stable kinds, which is the perfluoroalkyl substances. Next slide. So as Shaina was mentioning, its properties make it very useful in many commercial products. It can repel oil, stains, heat. It's been used in food packaging, non-stick cookware, so the Teflon, water-resistant clothing, upholstery, carpets. It also can lower surface tension and therefore is used in many applications from the aerospace, medical, electronic, automotive industries. It's also a common component in the AFFF, or aqueous film forming foam, that's used in firefighting foam. Next slide. So just the next slide is not meant to make you stress out, but the point of this slide is basically to show you that not all aqueous film forming foams are the same. When it first was created, it's known, well, the first one was called the legacy foam, and that contained PFAS. And as it was developed further, there was a move to make these foams with a shorter chain compound, and eventually to non-fluorinated foams. In fact, a lot of this has been spurred by litigation as well as legislation. In the 2018 Federal Aviation Administration Act basically is moving to phase out fluorinated foams by 2021. Next slide. So PFAS is an emerging contaminant and with specific focus on PFOA and PFOS. Those two are the most well-studied PFAS chemicals. And what does it mean to be emerging? So basically, these are chemicals that pose potential threats to human health and the environment. They're consistently found in the environment. So as Shaina was mentioning, 110 million Americans have been potentially exposed, and even more to PFAS chemicals. They lack sufficient human health and environmental impact data. And part of this is because it's a large family of chemicals. It's very difficult to test. It requires a lot of expertise and special testing methods to test these. And so we're still developing a standard protocol in testing these chemicals. And as time goes by, it becomes more sensitive. So before, we were testing at, higher levels. And now, according to what Shaina was saying, is that they can test that the sensitivity of these tests is down to 2.4 parts per trillion. But that doesn't include all of the PFAS chemicals. That's just a subset. And, I believe the last round of testing was up to, 25 compounds of the 4,700 compounds out there. So another important determinant, a key point to make is determining whether it's carcinogenic and non-carcinogenic. And in the regulatory framework, carcinogenic would require a lower level as far as what's allowable. But as you heard in the testimony from Shaina Casper, that if you look at endocrine disruptor studies, it's not necessary for it to be carcinogenic, for it to be harmful to health. And especially when we're dealing with vulnerable populations, developing fetuses, children that are still growing, and they consume large amounts of water comparison to their body mass. So as far as what is carcinogenic, so various agencies are on, they're making the determination whether it is a carcinogen or not. And it looks like PFOA is the one that is more the, at least in the information that I have here, it is a potential carcinogen, but according to US EPA, it's both PFOS and PFOA. Next slide. So other things, besides a carcinogen, these chemicals are persistent organic pollutants as determined by the Stockholm Convention. And what that means is they don't break down easily in the environment. Some of the other chemical that you may know of is dioxin, is also a persistent organic pollutant. There is move to also, so PFOS is identified as a POP, or persistent organic pollutant. There is a move to identify more or list more as persistent organic pollutants. And knowing what we know about the chemical makeup, it seems to make sense. The other determination that needs to be made is whether it's a hazardous substance. And what that means in the regulatory world is that it would require additional, it would basically provide more teeth to enforcing cleanup. So as of now, we don't have a very clear picture of how we should handle these, and it's really up to our local agencies to take proactive steps to minimizing and eliminating even these chemicals. Next slide. So in the testimony early, there is links to immune effects. It affects the liver. There are adverse effects to growth and development of infants and children, decreased fertility among women, as well as increased cholesterol levels, a potential carcinogen, and a hormone disruptor, a thyroid hormone disruptor. Next slide. And of course, PFAS is widespread and it's very mobile. It can infiltrate water sources readily. It persists in the environment and in our bodies. As you heard, it 2 to 8 years for it to clear in the human body, potentially. It's detected in blood serum, and there's also current studies being made for different communities to determine what their levels are. Next slide. So PFAS contamination has been found in industrial sites, so areas that have manufactured PFAS, fire training and fire response areas because of the foam that's used. And the reason why it's used in foam, because it's found to be effective in stopping these hydrocarbon fires. Department of Defense sites, landfills, airports, wastewater treatment, and biosolids. So it's common, this is where you would find them commonly nationwide. The exposure routes mentioned was through drinking water, food contamination through food like fish, packaging. It could be transferred. It could be transferred through breathing in dust, as well as dermal transfer. So if you touch products, that you can absorb it. Next slide. So the history of use of aqueous film-forming foam. So here, Department of Defense has used it. So here, according to many documents that we've come across from the Government Accountability Office, from legislation such as the National Defense Authorization Act of 2017, 2018, 2019, and currently 2020. The report from Department of Defense to Congress in June 2018 and other documents basically show that Department of Defense has used this chemical. In the 1960s, the U.S. Navy developed these foams because it provided a better fire protection than the old protein foam. It's been estimated that of the PFAS-containing foam, about 75% was utilized by the Department of Defense. And some of these formulations may contain PFOA, and there's still inventory within the Department of Navy that they are working towards reducing or eliminating completely. We also know that the Air Force has released foam in the sewage system as well in 2018. Yes, in Guam. According to an October 2017 Government Accountability Report, quoted, Department of Defense data for fiscal years 2013-2015 indicate that the Department of Defense public water systems complied with the Environmental Protection Agency and state health-based drinking water regulations at levels comparable with other systems in the United States. However, the military departments did not report all violations to the Department of Defense. So while 77 installations reported violations to Department of Defense, Government Accountability Office found that at least 16 installations did not. Department of Defense has not used its data to determine why its two types of systems, one that provides Department of Defense treated water and another that provides non-Department of Defense treated water, have different compliance rates. So Department of Defense data indicate that about 99% of the people who receive non-DoD treated drinking water were served by systems with no violations, while 89% of the people who received the DoD treated drinking water were served by systems with no violations. Next slide. So some of the current actions of the Department of Defense include the Navy's in the process of identifying locations and preparing to remove this aqueous film-forming foam for proper disposal and destruction. There are efforts to replace the legacy foam with one that reduces the PFOA exposure. The 2018 National Defense Authorization Act basically required biomonitoring through the CDC, which is being implemented by the CDC and ATSDR. Some of the protocols by the Department of Defense include 4715.18 emerging contaminants. So DoD currently is completing a preliminary assessment site inspection at Naval Base Guam, has recently sampled surface soil on Navy-owned property. And the soil results are pending. Investigation for PFAS use, handling, and storage identified facilities and sites, including Naval Base Guam, NICTAMS, Barragata, Nimitz Hill, Naval Hospital, Naval Base Guam, Ordnance Annex, and NCTS Finnegadson is being engaged. The preliminary assessments is also under development for Anderson Air Force Base. So according to September 2018 report, DoD has identified 401 active and closed military installations with known or suspected releases of PFAS and PFOA. As of December 2016, the military departments had reported spending approximately $200 million at or near 263 installations for environmental investigations and responses to PFAS and PFOA. According to DoD, it may take several years for the department to determine how much of it will cost to clean up PFAS and PFOA contamination at or near military installations. DoD reported taking actions as of August 2017 to address PFAS, PFOA levels exceeding those recommended in the EPA's health advisories for drinking water for people in 13 installations in the U.S. and outside 22 military installations in the U.S. According to their DoD report to Congress in June 2018, DoD has proposed a 380 parts per trillion cleanup level for PFAS and PFOA. Cleanup costs so far are estimated at $2 billion or more for Department of Defense. Next slide. So this picture depicts basically how exposure can take place. Although the site of use may be far away, as we said, these chemicals are highly mobile. It can be transferred through any water source. It could also be transferred in the air through dust, and also through, it's bioaccumulated in animals and plants, so we can be exposed through our diet as well. So we can skip to the next slide and the next slide. So that's just basically another, these are other cases. It's the same process of exposure, but different sources. Okay, next slide. Okay, so the case study, New Jersey. So right now, New Jersey is the only one that has an MCL limit, which basically determines the level allowable in drinking water alone. It doesn't set any standards for soil, soil or groundwater that's not used for drinking water. So for now, actually, they've set an MCL for PFNA. It's perfluoronoanic acid. They set it at a level of 13 parts per trillion. So right now, the health advisory limit is at 70 parts per trillion. And I think back in 2014, it was at 200 parts per trillion. So as time goes by, as the methods become more sensitive, as toxicology studies come in, the levels are being lowered, so we don't have a fast rate or a level at which we're setting it at federally. So that's going to take some time federally to determine the level because of all the studies. So this is just a slide that shows New Jersey's efforts. They're one of the leaders in setting standards. So again, they're setting standards for groundwater quality, as well as they're listing it as a hazardous substance, which basically sets forth more cleanup. So for PFOA and PFOS, there is an interim groundwater quality standard. PFOA is set at 10 parts per trillion. PFOS is also at 10 parts per trillion. But currently, their rule proposal for April 2019, it seems to be increasing up to 14 parts per trillion for PFOA and 13 parts per trillion for PFOS. There is also a move to add it on their hazardous substance list and to include it in private wells. So for Guam, it was detected during a cycle of testing under the Safe Drinking Water Act. It's called the Unregulated Contaminant Monitoring Rule. This was cycle 3. And so in Guam, there were 6 PFAS tested on Guam's drinking water sources. And there were 2 types that were detected, PFOS and PFHXS. Were detected in 6 wells. In 2016, GWO resampled, and they found that they detected it in 5 wells upon resampling. The highly contaminant wells A23 and A25, NAS1, were shut down at the time. So NAS1 is located in Naval Air Station Agana in Tidzin at the Guam International Airport, and A23, A25 are off-site, but they're downstream from Tidzin. Currently, A23, A25 are still shut down. NAS has been, they've placed a GAX filter, and so it's in operation right now. So in 2017, there was a community effort to include Guam in the biomonitoring of PFAS chemicals made by the Guam Coalition for Peace and Justice and the Northern Guam Soil and Water Conservation District. So these, the next slide, I don't know if you can see it, but these are the results from the testing that was done in 2014, 2015, and 16. And so you'll see Anderson Air Force Base, non-detects, there was a 2.5 at some point for PFHXS, perfluorohexane sulfonic acid. and the Navy, there was non-detect. So keep in mind, non-detect is a moving target. It depends on the testing. We have to be able to define that depending on what type of methodology was used. And then if you scroll through the next slide. So these are the wells that tested positive at their different dates, different times, or different dates, I should say. So NAS 1, 44, this is I forget what level, it says micrograms per liter, but that needs to be verified. So there was positive, wells that have tested positive for various PFAS, of the 6 PFASs that were tested. So we have A4 that was tested positive, A23, A25. So A25 and 23 were the ones that exceeded the 70 parts per trillion, which was the health advisory limit. A30 also had a 30 parts per trillion. And so these are the wells that have tested positive for PFAS. Also the Agana Heights tank, there was a measurement made where they found perfluorohexane sulfonic acid as well as perfluorooctane sulfonic acid. Yes. The airport also was tested positive for those 2 compounds. The tank itself. So this is the results from that initial testing. So next slide. So there are now currently bills on the legislative agenda that seeks to address this problem. Bill 174-35, which seeks to establish a maximum contaminant level in drinking water, which is a legally enforceable limit. It's co-sponsored by Senator Therese Terlahi, Vice Speaker Nelson, and it's introduced by my office. The other bill is 163-35. It allows the AG to establish a contingency fee for litigation on PFAS, PFOA, and other contaminants, introduced by Senator Therese Terlahi. Next slide. The bill that was recently passed, Pratehi Ihanam Act, which authorizes the AG to participate in the multi-district litigation, which we just received an update today. And there is a resolution 168-35, which urges inclusion into testing of sites by DOD, and introduced by Senator Nelson, co-sponsored by myself and Senator Amanda Shelton, or just co-sponsored by myself and Shelton. Yes, thank you. Okay, so that is the background information thus far. At this part of the agenda, I would like to ask Guam EPA to have a seat at the table and to provide testimony. I did send questions ahead of time, so if you would like to just speak to those questions, and we can have follow-up questions by our panel here. And for the record, if you can introduce yourself as well and your position.
Good morning, Senators. Walter Leangaro, Administrator, Guam EPA.
Good morning, Senator. I'm Brian Bearden, U.S. Public Health Service, detailed through the U.S. EPA to the Guam EPA, and I'm serving as the Chief Engineer and Water Division Director at Guam EPA.
Do you have a prepared statement, or do you want me to ask the questions?
I would prefer if you just ask the questions and then we
All
can
right.
answer.
Okay, sounds good. Okay, so this can go to either one of you if you want to chime in. So the question, first question is, what role does Guam EPA have in setting regulatory levels and regulating PFAS chemicals?
Okay, well, we regulate, or we administer regulatory programs for drinking water, surface water, groundwater, and site remediation. So once we receive a regulatory limit, whether that's established through U.S. EPA or that we would promulgate locally, we would then administer that program to enforce those regulations. So we cover all those media. Ordinarily, we utilize regulatory limits that are established by the U.S. EPA, especially for drinking water maximum contaminant limits. Guam EPA has never adopted its own MCL. We also utilize other standards that U.S. EPA adopts as well for surface water standards, site remediation goals, et cetera.
Okay.
Senator, I'd just like to add, and I may be adding this throughout the course of the questions that you sent, that there's a concern at Guam EPA of establishing MCLs because it's a long drawn-out science, and currently Guam EPA does not have that technical expertise, and we rely on EPA. And so I just wanted to put that out there initially, sir.
Okay. So can you explain the process of regulating PFAS? Which PFAS will be regulated, and what is its anticipated timeline?
Yes, so as you know, currently we have the EPA Health Advisory, Drinking Water Health Advisory, which set a number of 70 nanograms per liter, which is 70 parts per trillion, for PFOS and PFOA only. It did not include any of the other contaminants. Guam EPA has taken that number and worked with GWA to take action as soon as we knew about that number back in 2016. We spoke with US EPA to find out what their current take on the schedule is for regulating. At the end of this year, the end of 2020, US EPA must move forward with its regulatory determination, which is basically a go, no-go decision by the administrator of the United States EPA on whether to regulate PFAS components. If they decide that it does need to be regulated at that point, then they will move on with developing a proposed standard, which our understanding is that that would be an MCL. And that they have a 2-year regulatory or statutory limit to set their proposed standard. It could happen quicker. They believe it would probably happen quicker. At that point, then they put that proposed standard out there for public review. They have 18 months after that process to issue their final rule. And then beyond that, they often issue a kind of a time period for utilities to comply that can be up to an additional 2 years. So it could be as many as 4 to 6 years before we see an actual MCL from the US EPA. That's our understanding.
And if I could add to that, Senator, most emerging contaminants, when they actually do meet the regulated level, the studies can actually take anywhere from 10 to 12 years. US EPA, due to the PFAS before issue and its complexity and its possible ill health effects, they have fast-tracked this. They've put their mind to it, I believe, 2 years ago, and so they are moving as rapidly as they can in their science at this point that they feel comfortable with. In fact, one of the things, and we'll get into the discussion, is the previous speaker talked about some of the levels that should be done, and I think she has a great thought process going. Unfortunately, because a lot of these studies have not been done in unison, even the states, as you well know, as you showed, most of the states in the Northeast, they can't even agree to what the MCL should be. One state has put it out there, but others are looking at it that do have toxicologists. And yes, usually the numbers currently are lower than the US EPA Health Advisory, but there's no general uniform number that everybody agrees to at this point.
So, Mr. Bearden, you were talking about go, no go. What happens if they say no go?
Right. If they say no go, then they will not take action to regulate it as an MCL. I forgot to mention also that EPA has already proposed groundwater levels for the CERCLA process, both the groundwater standard, which would be the cleanup standard, and the screening level as well, which Walter can explain maybe what the difference between a screening level and a groundwater standard is.
So again, US EPA tried to fast track it, and knowing that DOD in the past has been a primary source of a responsible party, a lot of the meetings and information conferences and teleconferences that I've been involved in, DOD basically said, US EPA, you have this process. If you really think it's a problem, you can put this under the circular hazardous list. It is almost there as far as being able to regulate it under the circular guidelines. And that in itself will help Guam because, as you know, we do have our Green Parcel Des Moines program division does do the circular cleanups, which is basically DOD's installation restoration program, their BRAC program, their environmental restoration program. So we do have regulatory oversight once US EPA puts it on the circular process.
So, but if they say no-go, that's for the MCL, but are they also working towards the...
I understand your question, Senator, and I can't give a definitive answer. I'm not US EPA, but everything is showing, at least, again, for the circular process, which is the first easier step to do it, it looks like it'll be done by this year, that there will be an established circular screening level, which means they basically have to clean it to that level.
Sorry, Administrator Leon-Guerrero, you're saying that they're going to establish a cleanup level under CERCLA?
That's what they're hoping to do within this next year, correct?
So has there been a report for the public to respond to? Has that draft report been sent out to the public?
Yes, the proposed cleanup, the groundwater remedial goal and the screening level were issued for public comment in April of this year. The public comment period closed in June. And we've also been told that the listing as a hazardous substance listing is scheduled for this October.
What are the levels?
That would just be for listing as a hazardous substance, which then allows it to be regulated in a circular. There's no level associated with that, but the levels for the groundwater remedial goal is 70 nanograms per liter, and the screening level is 40 nanograms per liter for PFOA and PFOS combined.
So just to recap, that it's on its way to be determined as a hazardous substance.
Under circular, correct. And they're hoping, as Brian mentioned, they're hoping to be able to designate, again, they're fast tracking. And so again, it's a hope to have the drinking water MCL established if they decide.
And that's only for PFOS and PFOA?
Well, the drinking water side, we don't know yet. It's still, it may be, but once they hit that go, no-go point, then there'll be a 2-year process where they establish what their proposed MCL would be. At that point, it could include additional chemicals, because as you've mentioned before, there's additional toxicological data coming out. So they'll have more information than they did when they developed the 2016 health advisory.
Okay, thank you. Any questions at this point to my colleagues? Okay. All right, so moving on. What is your understanding of the toxicological data so far in establishing this limit?
Well, we're not toxicologists, we're not experts in that, so I would hesitate to really give much, to say much detail, but we are familiar, we've read the EPA Drinking Water Health Advisory. It goes into great detail what that was based on. And we're familiar with the ATSDR toxicological profile. We've read that as well. I have quotes I could read to you that we prepared from those reports. The health advisory that EPA selected of 70 nanograms per liter, even though that they looked at a number of different endpoints such as cancer, immunoresponse type endpoints, they based it on the most sensitive that they found, which was those developmental endpoints they're based on mouse studies, I believe, that reduced ossification and reduced pup weight. And their statement in their health advisory was that by choosing the smallest limits, those are the smallest limits, that was also then protective of the other endpoints that they evaluated, including cancer. But again, that was it was mostly based on PFOA. They also looked at PFOS, and they determined that the two of those combined would be what the limit applied to.
And I'd like to offer that, and I didn't know that you guys could do the closed network or a teleconference, but if you would like to, we could establish a conference call with one of the toxicologists from Region 9 so that you could talk to them better. Again, what Brian said is we are not toxicologists and we can repeat what they've provided us. But if you would like to set up a call with one of the US EPA region's toxicologists, we can try to do that.
And just to let you know, we did talk to them. We've asked them to give us their best explanation of why other states are choosing lower MCL or potential MCLs. We need to clarify that there are no MCLs yet for PFOA and PFOS, so there's no real comparison yet. Their answer to us was that, and toxicology is basically an art at this point. When you get a number, you have a number of health studies you can look at. You have a number of different endpoints. One rat study or mouse study might be done for cancer, one might be done for immunoresponse. So toxicologists can choose which of those they want to work on. Then beyond that, they choose a number of uncertainty factors. And when you read through these development papers and the presentations we've received from New Jersey, you can see where they made those choices, and those choices have huge consequences. They can change things by factors of 100, 1,000 even. And so what EPA told us was that the difference between EPA's number and New Jersey's, for example, was that they chose different endpoints, number one, a different study, and they made different choices in the way they allocated those uncertainty factors. So it really boiled down to the individual choices of the toxicologists involved in each study. And it is worth saying that of the other, I believe there's, let me pull out the number here. We did look at how many other states are developing MCLs. Based on an ASTWA survey, which is the American or Safe Drinking Water Administrators Association, Association of State Drinking Water Administrators, they said that 7 states as of June were planning to set an MCL. We looked at those 7. We determined that really only 6 of them were, because Pennsylvania was listed as one of them, and Pennsylvania's website now says that they do not intend to set an MCL, that they don't have the resources to do so. And they're a state that's much larger than Guam as far as resources for the drinking water program go. But of those 6 states, so for example, for PFOA, the proposed MCL ranges from very small for Vermont, which is proposing a list of, 5 PFAS substances to be combined, concentration of less of 20 milligrams or nanograms per liter. Michigan says 9. New Hampshire uses EPA's number. They're using 70, or they're proposing it right now. For combined, but for PFOA alone, they're using 38. New Jersey says 14, New York says 10. So they're all very different numbers. And so if we were to select a number based on another state, we already have a problem in that we don't know which one to choose. Each one has been based on somebody else's professional judgment, and it's very difficult for us to evaluate then which of those professional judgment to use. So that's why in the past, we've always utilized, and the whole country has utilized, the US EPA, because those judgments are made in a national setting where everyone across the country gets a chance to have input on that.
Thank you. Can you explain what determinations were made to create such a different outcome? So what was the decision?
I did not look at
points?
the detailed rationale from each state, so I don't know. But as I said, I believe that each state chose different studies, different endpoints. I know that New Jersey used, I believe they used a mouse or rat mammary gland development study. They used an immunodeficiency development of plaque-forming cells to set either the PFOA or the PFOS. They used different ones for each one. And then it's those choices of those uncertainty factors, right? They might use a 10, or they divide the number by 10 for one of them. And in one case, they change that from 10 to 3, and then another one they use 10 for a different. There's usually multiple uncertainty factors that can add up to like a factor of 100. And so that's what EPA had told us, was that the numbers that they use versus what the numbers that New Jersey had used were just boiled down to a choice of those uncertainty factors and that endpoint that they selected.
So for the health advisory limit, what were those decision factors to bring it to 70?
I'd have to go back and look and tell you what those uncertainty factors they were. As I mentioned, they used 2 mouse studies for PFOA, which was the reduced ossification, which is delayed bone growth in mouse pups and also decrease birth weight of the pups. And the reason they selected those is because even though they're calling it a lifetime health advisory for a nursing mother or a pregnant woman, they're concerned that those development effects are very extreme. So that in that effect, it becomes a short term, and they even say so. That's a short term limit. And by setting it at that very conservative limit in EPA's words, they believe that's protective of all the other endpoints that they know of so far. But that was at the time of the study.
Thank you. So with the biomonitoring occurring right now, what is the report showing as far as levels in human subject?
We don't have any information on that. That's with the CDC and the ATSDR. We don't know. We had talked to US EPA about whether that was going to be occurring here. What they told us was that no location in Region 9 was selected for that study.
Yeah, so I saw an email that there was a potential to apply. Was that determination made?
No, so
Or was there
what
an
we actually did is we were working through NAFAC PAC. We actually made the request to say, hey, can we look to bring them in to have this discussion? And so there was requests done. Even US EPA tried to make Guam be one of the targeted Region 9 sites. And the powers that be at CDC and ATSDR, I guess, chose otherwise. But we did request, even Region 9 requested Guam be on it. And
So even Region 9 that covers California and other areas, they were not tested?
We were just informed yesterday that as far as the Region 9 drinking water program is aware, that no Region 9 locations were selected as part of that DOD, ATSDR, CDC study under the NDAA.
Are there going to be other opportunities for this testing to come?
I was talking with Jesse over there when you were showing up about their bill that you guys passed on July 3rd, and I'm hoping that there's more. We've made the request, and we'd like to work with you again and I don't think we need to wait for an opportunity. We could just go ahead and ask, and we'll ask US EPA to support. They did support us the first time, like I did mention. They did recommend Guam be put on the list. Just no Region 9 sites were picked.
Okay, thank you. So just for the audience, can you explain what is the difference between a health advisory level and the maximum contaminant level? So how might what is the difference on a regulatory perspective?
Well, sure. A health advisory level is a non-regulatory determination. It's information that's provided to states so that they can take action as they are able to. An MCL is a fully enforceable requirement. So once an MCL is established, for example, a public water system, which is what we regulate, would not be able to provide water that exceeded the MCL, or they would have to face enforcement action from us. The health advisory level at this point, is just an advisory. We have treated it as an MCL together with Guam Water Works. We have made sure that no water is being delivered to any public water system that exceeds the health advisory level. Once we knew about it, I don't know what the time frame was. I think it was within months. That was before I got here. It's not enforceable.
Yeah, I'd like to correct Brian's statement just a tiny bit there. We don't treat it as an MCL because it isn't regulated, but we do treat it as an action level. And GWA, as Brian had mentioned, GWA is totally on board in upholding that to ensure that the community of Guam doesn't get drinking water from their system that has anything above 70.
Thank you. What is the US EPA? Can you explain the action plan? If you can briefly describe what their action plan is for setting an MCL for drinking water, groundwater, and other media.
Well, it's similar to what I had said before. The process of setting the MCL now is underway with at the end of the year being the limit that EPA has to decide whether to set an MCL or not, and then after that, 2 years to create the proposed rule, then 18 months to create a final rule.
And as far as groundwater and, let's say, biosolids?
The groundwater rules, the groundwater remedial goal and screening level is already been proposed as of this April. I don't know what the time frame is for adopting it. Now that the public comment period has closed, I have not heard anything about a biosolids standard yet.
And are there any other media that's going to be regulated?
Not that I'm aware of.
What is the difference of regulating hazardous substances versus emerging contaminants, or substances that have yet to be classified as hazardous?
Well, if it's not classified yet, or if it's not regulated, then we can't regulate it. We have to have a number to go off of, or a designation as hazardous before our regulations can kick in.
So being that these chemicals are emerging, but you're saying that you're treating the 70 parts per trillion as if it was an enforceable amount.
Not quite, Senator. Again, because we don't have the regulatory authority over it, we also recommend, and so we can't, the term enforceable is not something that we could use at this point. And again, that's why I often stress with the cooperation with GWA, they have done it voluntarily. And that must be stated over and over because we can't enforce anything at this point.
So what would that look like? What's the difference between enforcing and...
So basically what GWA has done would be what we would be, if we were able to enforce it, that's what we would mandate them to do. And ensure maybe to be more frequency of sampling.
Yeah, I could add to that once you have an MCL, there's also monitoring requirements. Right now, there's no monitoring requirements to go beyond what we already have monitored. An MCL would require a routine monitoring for that chemical, which means that you keep a more constant eye on what's out there in the environment. You keep an eye on what's going into the water system. There's an additional cost, of course, associated with that, but that's the main difference.
Thank you. Can you explain the relevance of regulating PFAS as a hazardous substance under CERCLA and the implications for addressing PFAS without this regulation in relation to CERCLA?
Okay, in regard to CERCLA, basically, for those that don't know, CERCLA is just cleaning up former contaminated sites. If when, and it looks that way, the US EPA is going to enforce this as a hazardous substance under the CERCLA rule, then we can look for potential responsible parties where there is PFAS existing and bring them to the table and say, this is now an enforceable hazardous substance. You now need to determine the extent of the contamination, if any, the levels of the contamination, and the cleanup of that contamination.
Thank you. And also, as outlined in CERCLA, what processes are available to mitigate and remediate PFAS, given that PFAS have not yet been regulated as a hazardous substance?
I don't have a clear answer in that right now. The science is still new as far as just even being able to appropriately delineate the contamination or the impacts of the emerging contaminant. Some of the problems is because there's no set science methodology done, except for safe drinking water sample analysis. Labs can tweak their methods numerous ways, much like what Brian was saying about risk management to determine, the different risk goals, which is why there's different levels of potential MCLs in other states. Labs can also do different things that would result in different lab results. That's why for Guam EPA, we really endorse what US EPA endorses, because they have the resources to be able to go through the long sampling process to identify which is the best.
Can you explain this risk assessment process? Can you explain the risk, you were talking about the risk assessment that has to be done in order for cleanup.
So Brian was, and again, I think would be better that I put us in touch and have a discussion with the toxicologist. But anytime you do a risk assessment, you have to come to an agreement, or there should be an agreement on what your risk assessment goals are. Based on those goals, then you use your risk management decision points, and those could be numerous depending on what you're looking at. Brian mentioned he's not sure, and nor am I, what the risk management decision points that were used. That would be, I would need to look at it more in depth per state. But again, I think for this toxicology discussion, I would be more comfortable if we had who we use as our technical expertise and have the US EPA on the line to discuss that.
Okay, so some of the discussions or some of the things that I've read is that if you find something in parts per trillion in the environment, it accumulates in parts per billion. And so the way some of these states are setting their limits is they're setting it based on the most vulnerable populations, which are developing children. And so is that risk assessment going to be linked to that concept of what is going to be the maximum contaminant level in drinking water?
Those are exactly the type of risk decision management points that need to be agreed upon. And that's, again, it's like when we work with DOD to decide what risk management cleanup goals are. That's the kind of things that we look at, what sensitive populations are involved, what impacts that may be done to them. And again, those are decision points that I am not too familiar with as far as the specifics, but I do know that those are exactly what that's one of the points that you could be considering. Yes.
So what are the
Would you mind if I add something to that? Because we're mixing up two different things. So the way an MCL is determined is different than what Walter's talking about, the risk assessment. That's the site remediation goal. So they work in very different worlds. So oftentimes a site remediation goal will be set on a very site-specific risk assessment where you look at whether or not there's any risk at all that that particular site will contaminate drinking water or if children will be eating the soil. There's all these things you look at for a site, whereas a drinking water MCL is set one time based on just drinking water exposure for the entire country and the most sensitive populations.
Considering that PFAS is highly mobile, though, I mean, what is, it seems to me that the site, the weight of that, should, or at least it should take into consideration that, that this is a highly mobile substance. It can migrate off-site depending on where the water flows. So what other decision points besides toxicology in determining risk assessment?
Well, risk assessment is always a combination between toxicity and exposure. So it's, you could have an extremely toxic substance. In the toxicology class I took in graduate school, the professor showed a slide of a surfer with a shark fin behind him and then a wheat field. And he said, which of these settings do you have the highest risk of a shark attack, right? So if there's no chance that anyone will be exposed to groundwater that's contaminated, the risk is very low. And that's why site remediation goals are often site-specific, whereas MCLs, because you are already assuming people are drinking that water, are the more stringent of them. So usually the drinking water MCL, if you're talking about groundwater, will form the baseline, most stringent goal that you'll reach for. But in some locations, that may not be appropriate if there's no groundwater use or if the groundwater flows in a direction where it would never be used.
And yes, Brian tried to clarify, but when we were talking, that's the circular process. That's the risk management process that would be used instead of having that set MCL.
Okay, thank you. I know we'll have Weary talking about our wonderful aquifer and all our water resources in a minute to talk about, maybe that could potentially be a part of the discussion about where we set these risks assessments or how we determine the risk assessment or how we go about doing risk assessments. So the other question is, are you familiar with applicable, relevant, and appropriate requirements, that concept? And what is their significance in relation to PFAS?
So when ARRs are associated with the circular process, and so what you try to do is when you come into a site, and again, this is you basically come into a negotiation with the responsible party, the regulatory authority and the responsible party, and you come and you make decisions So you take a look at what are your regulations, the local, state regulations, as well as the federal regulations, and you determine which ones are the ones that would be impacting the site. And those are the ARRs that you would be used to associate with the cleanup of the site.
So it's a negotiation process, you're saying?
Basically, it's Guam EPA or US EPA basically saying these are the regulations that must be upheld. And basically, you use all your regulations. So even though it's called a negotiation, it's just a process that is needed to be done.
And the current regulations that we have are federal regulations, which Guam mirrors.
That's correct. For the circular process, correct.
Do we have any other regulations that are basically more stringent than the federal regulations?
We do have some of our cleanup requirements lower, not in the water division, but in the airline division, the RCRA. We do have some of them that are lower.
Okay, thanks. Should a PFAS investigation be carried out at a site where foam is used, but there are no records supporting that it contained PFAS or PFAS?
One more time, Senator, I'm sorry. I didn't hear that.
Would you recommend investigating a site where foam was used, but there's no record that it contained these chemicals?
So you're talking AFFF being used at the site?
Or just any foam, so of unknown, from unknown contents. Would you recommend that it be investigated?
So being an administrator, being an employee of Guam EPA, I like to think that I err on the side of protectiveness of the community. Maybe some people think otherwise, but based on that question, even though there's a lot of variables that I would like to know more, but I would lean towards the side. I would, if there was an impact that would affect the community health-wise, I would definitely look to try to attempt that. Problem with things like that is, and I know it's a really sad statement to say, but sometimes the money is the driving force to be able to do something. And we don't have a lot of funding to do just sample anywhere we can.
Okay, thank you. Can you explain the role and importance of the unregulated contaminant monitoring rule, the third, and also can you talk about the fifth cycle that's coming up?
Well, the third unregulated contaminant monitoring rule, well, first of all, for anyone who doesn't know what the UCMR is, it is the mechanism by which, part of the mechanism by which EPA begins to establish new MCLs. This is why it's often a multi-decade process. It'll start with the candidate contaminant lists, which is developed nationwide. And these are the emerging contaminants that people are concerned with. If it gets on that list, then EPA pushes it forward into the next phase, which is to find out how widespread these chemicals are in the environment. And they do that by the UCMR, where they require monitoring throughout the country to find out how, these different chemicals, are they really truly widespread in the groundwater? Are people being exposed to them? So the UCMR 3, the sampling for that took place back in 2014 and 15. It included the PFAS constituents that were included in the EPA method 537 at that time. I don't know the total number of those, but based on it's publicly available data, anybody can download this off of the EPA website. Based on that data, there was 109 water wells in Guam that were sampled during that time period, usually 2 sampling events per well. And that included also a surface water system, the FINA reservoir, operated by the Navy. PFAS compounds that only, they were detected in 6 wells out of those 109. The detections included only PFOS, PFHXS, and PFHPA. We did not detect any PFOA, which is the main subject of the EPA health advisory, but PFAS is also included in that. So that was what alerted Guam to the presence of these chemicals in our aquifer. So I guess that's what I would say the importance of that is, and that's what triggered then, of course, the movement by Guam EPA and Guam Water Works to try to take care of that. UCMR 5 is still under development. There are PFAS compounds that will be included. Nothing is final on that. We can't really provide any detailed information on that. It's still, the sampling is due to take place 2023 through 25. As more information becomes available, we'll know more. As far as analytical methods, it's still under development, up in the air. We're not sure what detection levels will be by that time, but it will give us more information, for sure.
So to your knowledge, you don't know the list of chemicals that are going to be tested?
I've seen a candidate list, but we did not bring it with us because it's not final.
Of the PFAS chemicals, which ones are listed, are going to be tested?
Again, I don't have that list with me.
Okay. And again, you're not familiar with the methodology and the sensitivity of that methodology?
No, and I believe that's still under discussion and development. They've got ideas. They had a webinar last week about it, but they're not yet saying any of that's firm. I mean, UCMR 4 is still not kicked off yet here. That's something that was just approved recently by EPA. That monitoring should start later this year or next year.
And was PFAS included in that?
UCMR 4 did not include any PFAS chemicals.
Okay. How should investigation-derived waste at PFAS sites be disposed of?
I think we asked this question of US EPA, and even their answer is at this point, there's just so little known about this. It's such a new topic that there's no procedures yet. There's no guidelines, so it's still something that they're developing, guidelines for that.
So when we filter it out of our water, where should we put that then? What's the guidelines at least? There should be some guidelines.
Yeah, we still do not have guidelines. We don't know what to do with the carbon from these GAC filters yet that have PFAS contained in it. If we find PFAS in our sewage sludge, we still don't have an alternative yet for where that would be safely disposed. We're waiting and hoping, and so as is the whole country at this point.
Yeah. Again, because it's unregulated, there's no requirements at this point. If it becomes a hazardous substance, then the disposal would be regulated as such, as a hazardous substance.
Can the environmental restoration or ESCA agreements, how are they utilized to investigate and remediate PFAS?
Okay, so basically CERCLA requires that any responsible party, and you know, for Guam, most of our CERCLA sites, or anything that deals with CERCLA is, unfortunately, the military. But what would occur during the cleanup and investigation is the proper science behind it would be utilized, and that's kind of why I'm not hesitant, because I know this needs to be addressed for the general public. It's just even the sample methods outside of safe drinking water, which is the only one that has been standardized by US EPA. What I was trying to mention earlier, you can modify different methods, and depending on your modification of your lab methods, you can get different results. So without a standardized sampling method of soil or sediment, it will be dependent on who's actually paying the lab to do the modification, on what type of modification they would want to do.
It seems like there's a problem here because, you know, we're making a move towards, you know, eliminating, phasing out PFAS, but when we do these cleanups, it's like, where are we going to put all of these chemicals? I mean, that's a huge loophole. And if we're trying to minimize exposure, you know, that needs to be addressed. Do you know what the action plan is how the US EPA is going to address that?
I don't know exactly. I do know that they are looking at that, because that's, you know, they're looking at whether or not this stuff will stay in a landfill if you put it there, or if it will migrate with the leachate out of the landfill and back into the environment. They're looking at all that stuff right now. The science is still developing, and until they can figure that out, they won't be able to give us very good recommendations on how to get rid of it. I'm not even sure if it's if you can destroy the carbon with an incineration at this point and safely remove
That's my understanding, and I think if it reaches the CERCLA hazardous substance level, which I'm assuming it will be done by this year, then any contaminated charcoal would have to be disposed as a hazardous substance. And what has been done is they send it to, as Brian mentioned, facility that can heat it up beyond just regular incinerator levels, you know.
So because PFAS is an emerging contaminant, what has GPA done, Guam EPA done as far as consultation with GovGuam agencies to develop standard operating procedures pertaining to the use, management, and disposal of these substances?
So again, working with GWA after the discussion, GWA has voluntarily decided to remove the exposure of above 70 to the general community. I don't believe any of the charcoal from their GAC systems has been removed due to PFAS. If it becomes a hazardous substance and it is above the levels, then it would have to be disposed of as a hazardous waste. But currently, no exposure from drinking water is being done.
Have you consulted with other agencies like Airport Authority, Guam Fire Department? Have you taken proactive steps to basically communicate procedures on how to handle and use or handle and dispose of PFAS?
At this point, not directly, though we're conducting an investigation under the Guam International Airport under ARF, which we're trying to look into any of the disposal methods that may have been done, but we are currently looking into that, Senator.
What is ARF? Can you explain for the public? You said ARF.
I'm not sure. It's an acronym. Thank you, sir. Yep.
Thank you. Are permits required for the releases into the environment? What is your take on that?
Okay, so that's kind of a tricky question. Releases are not usually planned. Now, if you're talking about something that is being done like the sewer system and things, yes, there's a required permit for that. But when we talk more about releases, it's more like an accident or an emergency that is established. But for PFAS, there's nothing that is permitted as far as, because it's unregulated, we still do not have any permit process for that.
Is that something you're going to work towards as far as developing how to handle discharges into the sewage system?
Yeah, good.
Well, discharges into the sewer system are covered under the U.S. EPA permits for each treatment plant. They have an NPDES permit issued to GWA, and under those permits, and we can let GWA talk to that a little bit more, but I do know that under those permits, GWA must have its own discharge permitting program. So they have to review and approve any discharge of non-domestic waste, any kind of industrial waste, and that would include any PFAS. So, and I would like to just add with the Guam Airport Authority, we had discussed this, and prior to this investigation where we learned that there may have been some improper disposal, we had been assured that firefighting foam was only used in an accident and for specific training uses authorized by the FAA regulations, and that was our understanding.
Has Guam EPA consulted with ATSDR to develop site-specific response actions to PFAS in the environment?
Again, through the cooperation of US EPA and also the Navy, we made the request for them to come out. I did not speak to them directly. At this point, I've not spoken to them directly, no.
I'd just like to add that we have spoken to US EPA about receiving some ATSDR assistance in risk communication. That's one thing that they've always, they have staff that are located in the EPA office in San Francisco, and that's something they've helped with in the Pacific Islands for many years, is risk communication, and we have asked for that assistance as well so that we can make sure that the public is receiving accurate information and not anything that would cause an unnecessary panic. And that's something that ATSDR is very good at, and I've worked with them in the Northern Mariana Islands before doing that.
Okay, thank you. So I think that's a list of questions I have. I would like to open the floor to my colleague, Senator Tulahi, if you have any questions.
Yes. Can you just clarify? So there's testing set by DOD, as Senator Perez outlined, and that monitoring is being done by GWA on the wells. But do you do any testing or monitoring in addition to those?
Unfortunately, not yet, Senator. We've had the discussions about looking if this becomes a regulated contaminant. What are we going to do again? Because Senator Perez's presentation was so thorough, but we've had internal discussions. Exactly what her presentation showing. What are we going to do about the biota that may be affected? What should we start looking at? I did try to discuss with the AG's office to ask the judge about increase the sampling of the groundwater around ORDOT, just to include PFAS if it's not done already. Yeah.
Sorry, say that again about ORDOT?
So because ORDOT is currently the monitoring plan is currently being done under regulated contaminants. So there needs to be a request that we will do through the AG's office to ask the judge to include that as part of the monitoring requirements, correct?
Okay, and what about when the discovery of A23 and A25 that they were contaminated? And then I was reading Weary's report, I think this is from 2018. So back then, they had made some suggestions as to where, they would go next to look for the source. We're looking for the source, I'm hoping. So I'm wondering, are you involved in looking for the sources of those contaminations?
I've been part of the discussions with Weary and GWA. I know GWA is, again, they're in the process of their investigation. That I'm trying to work with them. There's been a new potential source, but it's not been verified, and since GWA found it, I'd leave that to them to answer it. But there's some potential new source that may exist.
All right, well, why aren't you more adamant, I guess, about these potential sources? Like, why aren't we aggressively ruling them out or pursuing whether they continue to contaminate?
It's somewhat hard to, and I know it's all lays on my shoulders that I need to rebudget if I wanted to do sampling out there. But because it's unregulated, I don't have the authority to enforce anybody to do any investigative work. It's basically has to be a cooperative agreement that we're looking to do this for the betterment of Guam. And I can say that Weary and GWA have stepped up to the plate on this emerging contaminant. But again, what I would have to do would be try to reallocate some of my budget or receive extra budget to start doing investigations of that sort.
All right, thank you. Thank you, Madam Chair.
Thank you, Senator. So just to kind of recap your position as a regulatory body on Guam, is that basically are you waiting on the federal government to determine MCLs and whether it's listed as a hazardous substance? Or are you taking extra actions to go beyond that?
Okay, so definitely for MCLs, we would definitely wait for US EPA. It would be our recommendation. As far as the circular process and hazardous substance, that I think will, first off I want to say, I think PFAS and PFA is a contaminant that we should be concerned with. And I think it needs to be addressed. And I do feel it is being addressed by the federal government. I do think that the strong possibility that it's going to be part of the hazardous substances list of CERCLA, most of the issues that we have on Guam will be addressed. But what makes me more comfortable, especially, is with the cooperation that GWA does to not give this as a potential contaminant in the drinking water. So, again, being unregulated, it's tough for me to thoroughly address it. But working with the Navy at this point, I know that they know it's something coming. It's just a matter of what the cleanup goals are going to be.
I'd just like to add on the side of the drinking water side of things that, Guam EPA and GWA did take some very proactive action when they found out about the EPA health advisory. And on the issue of waiting for an MCL or not, we know that you've proposed that bill, or you put out that bill to establish an MCL. Our feeling on that is that an MCL tends to imply that we're a lot more certain of the science than we are. We agree that action should be taken. Action is being taken. We would like to propose as an alternative to call it something other than an MCL, call it something like an action level or a response level, and then specify what those responses would be. Basically, that we don't allow water to be served to the public that exceeds those limits. And then that would get us the same effect as an MCL without us sticking our neck out there where we don't have the confidence to actually establish an MCL.
Who's responsible for ponding basins? Like, who tests ponding basins, or does anyone?
We have a underground injection control regulatory program that doesn't test ponding basins. It only tests underground injection wells, which would be the underpavement style ponding basin. So if you've got an infiltration basin that's under the pavement and it meets certain criteria, we require those to be tested. If it's an above ground open ponding basin, there are no testing requirements. We have stormwater design standards that were developed. I worked on that back in the early 2000s with CNMI and Guam that require certain types of treatment techniques before it gets into that. But we don't do any testing of that. It would be prohibitively expensive for the public of Guam. It would be almost every establishment in northern Guam that would have to run such tests.
So,
What about the tests you're doing on the dry injection
so
sites?
can I just clarify that
Sure.
just a little bit? So, like ponding basins, we do regulate the building and construction of the ponding basins, but we do not regulate anything post-construction.
Except for these underpavement systems that fall under the injection well program.
Those underpavement ones, do you test for PFAS or related?
No, we do not. We test for a variety of things, oil and grease, things that we would expect to see in a parking lot. And even that, we receive quite a bit of a pushback from the regulated community on the expense of that. PFAS testing my understanding is that it's well over $1,000 per sample. It would be very difficult to try to enforce that. If we knew that there was a source in that location, that might be something different. But at this point, the only sources we're aware of are not something we typically find in a commercial parking lot.
Well, they suggest some sources related to the A23 and A25 wells that, I don't know, lead me to believe they talk about ponding basins and dry injection wells that were developed because of flooding, and that this is the same source of water that they're, I guess, suspicious of. So I don't know, I'm going to hear from them, but it just seems to me that at least in those areas, we can narrow it down if there's any ponding basin or dry injection well that is contaminated, we are closer to the source, right?
Well, I think what you're talking about there is an investigation. That's a different matter. If we're investigating a potential release, then absolutely we would want to sample those locations. But as a general practice, I wouldn't recommend it for all of Guam.
Oh yeah, no, I'm talking about pursuing further the source for A23 and A25.
Yes, absolutely.
All right.
And we've heard some, again, unsubstantiated stories that may very much validate that it could have gone through those ponding basins from a different source.
All right, well, I hope you will investigate those. Thank you.
Thank you so much. No further questions at this time. So I appreciate your being here today. I would like to call up Senator Hope Cristobal, I apologize you've been waiting for so long, and I appreciate if you can come up to the table. And also Angel Marquez. So we have our community people that are going to provide some information or testimony. So if you like, yeah, thank you.
Shidus Masi, Senator, and the Committee on Environment, Revenue, Taxation, and all the above. Shidus Masi for this informational hearing. For the record, I am Hope Alvarez Cristobal. I'm from Tamuning, and I want to extend a danklo na Shidus Masi to the Mina 85 na Legislatura en Guahan for holding this important informational hearing on this very serious topic of PFAS, a dangerous and toxic chemical that have contaminated our municipal drinking water supply. One of the 5 that were identified as contaminated is back on the grid, and the public does not have much information to explain what, if any, type of PFAS filtration or treatment system has been implemented or guidelines recommended to prevent its recontamination. I want to make clear at this point, though, that I am not a scientist, I'm not a chemist, nor do I pretend to be one. I am, however, an interested and concerned member of our community, learning and educating myself about water and soil contamination, and one who is currently medicated for cancer. It has been an uphill battle in the past year and a half just trying to obtain existing data currently dispersed across many sources in government agencies to make sense of current and historic levels of water and soil contamination on this island. When the news broke out a year or so ago about the Central Municipal wells found to have high levels of PFAS chemical, it was important to learn more about the safety of our drinking water. The former NAS at Tijan was my focus because the source of toxic chemicals is basically found where past military activities occurred. But of course, we all realize that a great majority of contaminated sites on our entire island are within and outside U.S. Navy and U.S. Air Force bases. Senator, I would greatly encourage your committee to expand the breadth of your research to cover all toxic contaminations on Guam, not just the family of PFAS. And by the way, just to share with you, I was able to download from the ATSDR. They have flyers that we can use for the general public to educate on PFAS. And so I've provided you some copies. I was hoping staff would be able to provide that for those in attendance here today. Excuse me. I would like to elaborate my concern about contaminations, not just for PFAS. And I have stated this before here in this legislature, that there have been many environmental assessments performed over the years by the military, U.S. Navy, and U.S. Air Force, either directly or through private contracts. It is important that the government of Guam, in developing good public policy, identify potential and current contaminations with chemicals involved and educate our public on prevention of health impacts. When enumerated by each of their separate locations, you will find at least 100 of these sites on Guam. They include Superfund sites, the FUD sites, the formerly used defense sites, and installation restoration program sites. For over 75 years of military activity, Guam shares a history of contaminations with other base communities in the States. The difference is that contamination in Guam is more severe than at and around many U.S. domestic bases for a variety of reasons. In Guam, there is a high concentration of military bases per square mile. Guam's non-sovereign and colonial status and its effect on attitudes towards our people's health and well-being. Guam's having been a battlefield in World War II and a central launching pad for the Vietnam War in particular, and our lack of visibility in U.S. national media, which has helped expose contamination problems in the U.S. and elsewhere. The chemical footprint of the U.S. military is highly predictable and consistent. It includes the use of extremely high volumes of petroleum fuels, including jet fuel, diesel, gasoline, benzene, perchlorate, and their combustion byproducts. The U.S. military used 86 million barrels of fuel in FY 2016 for operational purposes. Air Force bases are the heaviest consumer of these fuels. Extensive use of herbicides to create perimeters around bases and training areas and to defoliate areas from which enemy exclusion is sought, including Agent Orange. Extensive use of pesticides in military buildings, particularly in foreign and tropical environments, including in the past DDT and chlordane. Use of strong solvents to wash down jets, ships, tanks. These include trichloroethylene, TCE, or perchloroethylene, PERC, also known as VOC, volatile organic chemicals. Their health effects include damage to the nervous system and skin especially. These chemicals are easily converted to gas from liquid form, and when inhaled, damage the lungs. They cause cancer and birth defects. Heavy metals with high toxicity, including such things as arsenic and lead, used in ammunition. Training ranges can use millions of rounds a year, only some of which is or was collected after it is spent. Radioactive materials used in munitions from depleted uranium to nuclear missiles. Many of these are used in domestic, civilian contexts, of course, but what makes their toxicity and impact on human health more severe in military applications are several things, including the idea that national security institutions' needs trump all other institutional and human needs, and that it allows for less democratic openness, more secrecy in its operations. The related intense investment in military institutions, which allows for higher rates of consumption of the toxins that would otherwise be the case in more resource-limited contexts. The inequality that exists in places like Guam, where the military has chosen to place its facilities. They tend to be in poorer rather than wealthier areas, where residents have more clout. In Washington, for example, the military operates its bases in Guam with the impunity that comes with its colonial situation. While military personnel are also exposed to contaminants on the bases, and as workers with those substances, often more extremely exposed in those short periods of their deployment, presumably creating incentives to control contamination, those personnel have limited time on island and exposure to the contaminants in comparison to Guam residents, lifetime residents of Guam. Between extensive Navy basing around Appa Harbor and Anderson in the north, there is an underground path along the roads and over the northern Guam Lens Aquifer that runs the oil pipeline that takes fuels from the harbor to the jets and vehicles at Anderson Air Force Base. Off to the side of virtually every road on this island are sites of military contamination. These sites have been variously categorized. Military dubs the FUDs, formerly used defense sites. These include sites in use from U.S. invasion and reoccupation of Guam in 1944 after a brief but brutal Japanese occupation. The program was instituted in 1986 to deal with protests of the lethal contamination of land the Department of Defense has owned and operated in the past. I have a reason for bringing these things up. On the FUD's properties have been found whole tanks, planes, mustard gas canisters, construction debris, household waste, drums of various oil and other chemical contents dropped empty or full in areas throughout the island. Some hazardous waste are buried, others bulldozed over cliff sides, others simply left on the surface to eventually be swallowed by vegetation. The Department of Defense lists 17 sites of toxic waste or possible buried munitions. Many more have not received recognition. Soil and water tests required and funded by the FUDS program have found extremely high levels of the chemicals that I've just mentioned. Another set of contaminated properties are in areas returned to the government of Guam or private landowners in the last several decades of the BRAC closures, the rounds beginning in 1988. These areas of contamination must by law be cleaned, or more commonly referred to euphemistically, remediated with BRAC funds. So there we have some precedents. Security fencing or access limiting action, alternate water supplies, relocation of individuals, excavation of contaminated materials, installation of controls on contaminant migration, and other actions consistent with the final remedy. The DOD lists 51 such sites on Guam. Contaminated areas on existing bases fall under the DERP, or the Defense Environmental Restoration Program, Installation Restoration Program, established in 2001. The DOD lists 157 sites in that category. Sites on Guam's bases, as well as 25 base sites requiring response by the MMRP, the Military Munitions Response Program. Anderson Air Force Base has so much toxicity that it is a Superfund site that's still unremediated completely after over 25 years. A number of areas are considered impossible or too expensive to restore to even limited industrial use and have been cordoned off, presumably permanently. These dead zones occur throughout the U.S., but as well as on Guam, though at much higher rates per square mile on Guam. What existing programs do not do, however, is require an overview of the entire island's chemical contamination, require study of the cumulative and interactive effect of exposures to multiple chemicals over both short and long-term periods, and require biological studies of accumulation of contaminants in the human body and in the food chain and other biota of the island, and require the DOD present data on how much additional contamination should be expected as a result of the military buildup and the live fire training range complex. While there are a set of processes by which the Department of Defense or the services themselves are supposed to keep affected populations aware of contamination and cleanup, the data are so vast in scale and so complex, and the incentives to widely disseminate the contamination status of each of these many sites are so low that the people of Guam have been barely informed and not at all informed about these contamination or about the status of any cleanup efforts. The result is widespread sense of insecurity, fear of the environment, and particularly of the water and fish of our island. I get the sense that our local officials in charge with caring for the environment and the health of our island community do not always push for more transparency or more action to deal with contamination. After all, how do you hold the U.S. military accountable when we are powerless to prevent their contamination? Last year, I was invited to participate in a call for action by the Green Science Policy Institute in Berkeley. More than 6 million people are drinking water polluted with highly fluorinated chemicals. These substances used as stain and water repellents and in fighting aviation fires are associated with serious health problems, including kidney and testicular cancer, thyroid disease, decreased sperm quality, high cholesterol, and decreased response to vaccines. My dear senators, there is great need for coordination among Guam government agencies to protect the health of our people. Cancer is racing to the top of the list as causes of deaths in Guam. After the closure of water wells 823 and 25, located going up the hill to Sinahanya, GWA no longer monitored the levels of PFAS there. Why? WERI seems all too glad to study the paper trails of contaminations in their annual reports. And GIPA and Public Health have not had much to say to the community. We need a coordinated plan, and one has yet to take shape to protect our community and to clean up and to prevent further contamination by fluorinated chemicals or, for that matter, any of the toxic substances affecting our health and rendering our soil and water polluted and poisoned from military activities, who are largely responsible for most all contaminations on this island. Education is lacking in regards to prevention and cleanup of contaminations. We need good government policies, and it must always provide a seat at the table for the community voices. And we thank this legislature for continuing to allow our community to come, be up front and center in decisions that are important, especially to our health, as you have done today, Senators Perez and Terlahi. I thank you for this informational hearing. What we want to know is, what is the government of Guam doing? What is the plan to protect the people from dangerous chemicals, toxic contaminations being perpetrated on a colonial people by the continued militarization and contamination of our lands? Where can the people of Guam learn about all the technical information of chemical contamination that is killing us? As you can see, there is great need for increased transparency. Guam is an impacted community of PFAS. We need better testing of our drinking water. We need analytical methods for identifying all PFAS. We need technical assistance for cleanup. We need information on PFAS use. We need support for changing the mil specs on use of these insidious contaminants. We need a Guam enforceable drinking water standard that are protective of infants, children, and our most vulnerable community for the combined total of all detectable PFAS. And we need homeowner kits so we can test our water coming out from our faucets for PFAS. The government of Guam must deem PFAS a hazardous material or substance, and our agencies need clear authority for cleanup. We definitely need more information from the manufacturers and more independent research on PFAS besides PFOA and PFOS. Guam needs a cleanup plan, not mitigation. I am appalled by some of the answers to questions, attitudes about we are not toxicologists. There is enough research out there. As a matter of fact, in today's paper, across the U.S., there are companies now rushing to try to find ways to get rid of PFAS chemically. I don't know how, but it's absurd to hear our own government agency administrators, the attitude. In today's paper, which I just received in Washington, D.C., we have a senator there. Her name is Senator Jean Shaheen from New Hampshire. She's a senior member of the Senate Armed Services Committee who has issued a statement in response to the Department of Defense announcement that the DoD will establish a per- and polyfluoroalkyl substance or PFAS task force to combat the pervasive problem of PFAS contamination in water supplies throughout the nation that has impacted New Hampshire especially. But with help from these kinds of senators, I think we need to listen more carefully about what they are doing. Apparently, the new panel will be will compel substantial changes in DoD's approach to combating PFAS contamination. And confronting the issue requires a multifaceted approach, which really we should be looking at, because it's not just the PFAS that we're struggling against and the contamination and health effects that it has caused to our community, but I think all agencies should be part of a team approach, a multifaceted approach to end exposure, to remediate contaminated sites, and to accelerate research, development of fluorine-free firefighting foam, delivering urgently needed answers to the families who are affected about their potential health implications related to their exposure to PFAS. I would like to see a more comprehensive approach to address the PFAS exposure for our drinking water. 2 wells is too much. But the NAS-1 well, I've kind of drive there every now and then and just watch the people that are around that well. I have quite a few friends that live in that area that are severe stages of cancer. I'm not sure, and I'm not able to get the populations that are served by these wells. You know, PFAS is in the water at these 2 wells, but they must have, it travels very fast, and they must have been there for decades. People were exposed to PFAS or PFAS before it was discovered. So we need to have health studies. And it seems to me like the Department of Defense has, has been made to pay for some of these remediations. And although, the governor says we need to have status, it seems like we could bear on Congress and include Guam, because apparently the scientists, there were 36 of them at the Green Policy Institute in Berkeley that I was contacted by one to participate in the call for action in Congress. And apparently they are fully aware of all the contaminations on Guam. I would like to offer, a result of that call to action was a $10 million appropriation out of the NDAA for health studies, for the PFAS health impact study, as well as some other invasive measures that are being done for those that were impacted, which is unfortunate. Guam was included in that NDAA study, and it was up to our representative to vie for the money, and that did not happen. That was in the FY 2018 NDAA. So it's unfortunate, but I think we owe it to our people to continue gathering information as much as possible and to take it to the higher level senators, because there's a lot of information in the U.S. Yesterday I went to the webinar, July 16, 2019. I looked at the notes of U.S. EPA, the Office of Groundwater and Drinking Water webinar, and I was looking at the unregulated contaminant monitoring rule number 5. That's where they are at right now. And I find out that much of the work is voluntary. Say, for example, the administrator of our Guam EPA, it's up to him to decide where to take our issues that has to do with the UCMR number 5. And that process is still ongoing, and let's see, the final rule is in 2021. There's going to be the anticipated proposal this next summer. And this whole process of getting the unregulated contaminant monitoring rule, it seems to me like we have our work cut out. So I highly encourage EPA. I know it's voluntary, so we can, the legislature should be able to make direction with regard to that. Jesus Masi.
Suzu's Masi, Auntie Hope, Senator Hope. I thank you for your testimony. I think it's so important that we take more action in regarding inserting ourselves in these discussions, these federal discussions, when it comes to these draft reports. We're missing opportunities to really strengthen regulations here, I believe, if we are not part of those discussions. So I would like to definitely have a follow-up discussion with Guam EPA to see where we're at in these federal discussions and see how we can make this stronger here on Guam. And I also want to point out that, how do we address the cumulative effects and what your testimony brings to light? And, I remember growing up, we never drank the water. We drank bottled water. And I think that was just from this sense of knowing that our water could potentially be contaminated from, all the activity that's taking place above ground. Anderson Air Force Base is atop of our aquifer. A lot of the sources of water, they're connected, and we'll talk a little bit more about that. And I just think that, this is something that needs to be addressed. And I know PFAS is just a new emerging contaminant, but what about these other contaminants that are there? And we definitely need to follow up with this discussion as far as what do we do with all these contaminants that we've been exposed to and have yet to be cleaned up. And now we're dealing with one that's increasing. It's gaining more focus, and not only that, there's more chemicals being produced in this family of chemicals. So thank you so much for your words and your research and bringing this to the forefront. I understand that you're one of the first ones to bring this to light within the community, and so we thank you for following up with us and your words. Thank you.
Jesus Masi.
Do you have any questions? So the next community representative we have is Angel Marquez. He has a distinction of working for Guam EPA. He retired recently. So if you can provide some information regarding your experience in your knowledge regarding PFAS. I know you're involved with the UCMR3 testing potentially, and if you can bring some insight into what your experience was then, and how serious this is and what we need to do as a community. And sorry, if you can introduce your name yourself for the record.
Yeah, my name is Angel Marquez. I work Guam EP for more than 3 decades, and mostly in the drinking water. And thank you, Senator, for inviting me. And the information I'm going to share today is my opinion and my purview of the issue. It's nothing to do with my former employer. Although I learned this mostly while I'm working at Guam EPA. The UCMR3 requires PWS to monitor the source if there are more than 10,000 people population. In other words, there were 3 systems that did not, because they're not required, to monitor the peoples in PFAS, like the airport, the U.S. Air Force, PWSS, and the Southern GWA water system, because their population are less than 10,000 people. The airports have more than 12 wells that are vulnerable for this kind of contaminants. So there must be a requirement or a local law or authority for Guam EPA to enforce a mandatory monitoring of this requirement. One-time monitoring for a mobile contaminants not adequate. As you notice it in the result, sometimes it gives like 100, sometimes non-detected, and sometimes 200, because it's very mobile and it's only one time monitoring. It requires a minimum of 4 quarters monitoring to categorize the status of that particular contaminants. Again, especially a mobile contaminants. Guam EPA, true, they don't have the authority because there's no MCL to adapt. However, like in many other roles, like the lead and copper role, the MCL is not an MCL, but they call it the action level. The reason for that is that particular contaminant are required to monitor the contaminants to prevent or to protect the public health. So much so, if this particular contaminant, it could, so many ways, they can adopt it as a secondary parameters, which they have the authority or to enforce it or not. But what I'm saying here is a mandatory monitoring is a must. Right now, I don't think we had or we know exactly how many wells are contaminated or just based on just one monitoring. And also, the source of these contaminants, WERI is here on the island that support us. WERI had been supportive in the implementation of the leading copper role in this island. And because of the law that this legislature, this government had passed during that time, Guam, I believe, is one of the states that contained or had the leading copper that is being contaminating our drinking water. Because WERI had helped us, they have their laboratory to do the analysis, and also the law that you pass prevent us or prevent the importation of this illegal material to come to Guam, and they are being prevented to be used in the drinking water. That's all, Senator.
Thank you. Can you talk about, so what would you recommend for drinking water, so for contaminated sites pertaining to drinking water? So you were mentioning something in a conversation that you recommend pump and treat?
That's correct. Pump and treat. There should be an authority for Guam EPA. I understand there are more than 2 wells that are being secured because the public water system choose not to pump from that well, but to protect the groundwater lands. Those contaminants might migrate to other sources or to other wells. So Guam EPA don't have the authority to require the system to pump and treat if they found out that that well or that source is contaminated.
Okay, thank you. Do you have any questions? Okay. Thank you so much for providing your testimony. So we're going to have the next group come up, unless you have questions or no? Yeah, thank you. Thank you. Sorry. So the next group is Guam Water Works Authority, and we'll have WERI to come up to the table. And if you can introduce yourselves for the record. Yeah, it is cold. I'm sorry. Okay, so we're going to start with Guam Water Works Authority. If you could introduce yourself.
Good morning, Senator Perez and Senator Talai. My name is Miguel Bordallo. I'm the General Manager of the Guam Water Works Authority.
Thank you for being here. So when was GWA first made aware of PFAS, PFOAs as emerging contaminants?
Sorry, Senator, before we get to your questions, can I just address, make a comment on some of the information that was previously presented in your slide that I think Senator Chalabi might be interested in? The information on the Agana Heights tank and the sample result that was there. That sample result was not for water that entered the distribution system. That number was above the health advisory level of 70, but when we ran that sample, we were attempting to see if we could dilute water from one of the A series wells, 823 and 825. So we isolated that tank from the distribution system and pumped from one of the contaminated wells and blended the water with other wells that had no PFOS in it. And the result of that test was the 120, but it was not released into the distribution system. The tank was then diluted further. The well that had the PFOS was isolated, and then we filled the tank until the levels were below the 70 parts per trillion, and then it was released into the distribution system. So I just wanted to clarify that. I know that you had expressed some concern about that result, and I wanted to correct it. Thank you, Senator.
Yeah, thank you for actually reminding me about the results. So, yeah, going back to the wells that tested positive for PFAS chemicals, what are the current levels now? Have they been tested recently, or what's the frequency of their testing?
We continue to test quarterly for the wells that are active, and essentially right now that's just NAS1 on our system, and it's come back at 50 on the raw water, but non-detect after the treatment system. Contrary to what was previously presented, we do occasionally sample and monitor 825, in support of Wary's study on their study on the fate and transport of PFOS in the environment. 823 we did not. We chose 825 because it was the higher concentration of the two wells, and so that's the one that we've been sampling frequently. 823 we did not monitor because the well is offline. So we will stipulate that it's still in the ground there, but we find no value in wasting $1,000 and conducting the sampling for something we know is there that we're not running into the distribution system anyway. So until we get a treatment system up and running for 823 and 825, the sampling will remain as needed to support Wary's study.
So the other wells that tested positive, but for those 6 chemicals, there was a perfluorohexane sulfonic acid. Are you testing that as well? Are you continuing to follow that for the wells that tested positive back in 2014, 15?
So when we did the initial round of testing in 2015, we did two rounds. Multiple wells tested positive, but the ones that were, when in 2016 we did some follow-up sampling, and the number had reduced. I think we had 5 wells, I think, that tested positive in 2016. The ones that were of most concern when EPA lowered the advisory level, those were the ones that were 823, 825, and NAS1. And those are the ones for which we provided the public notice for the customers who receive water from that system. We did publish and send out a notice to those customers based on their receipt of that water. And then we also posted a notice on our website, so there was public notification at that time. Subsequent to that, those are the ones that we have continued to monitor on a quarterly basis as we were operating them. The ones that we shut down, as I mentioned, we tested those to support Wary study occasionally, but we did not continue that quarterly monitoring. So the only ones that we have been monitoring quarterly after 2018, or after 2016 rather, were the ones that were impacted, NAS1, 825, and a couple other of the A-series wells, which ended up being non-detects.
And that was strictly for which chemical? PFAS?
Whatever is in EPA method 537.
Okay. So the other wells that tested below the advisory levels, are they still testing? Are we still detecting PFAS presence?
We are not. The ones that went below and went to non-detect, US EPA and Guam EPA concurred that we did not need to sample those any further, so we did not, and we have not detected anything. However, I did instruct staff recently to prepare to do a comprehensive round of sampling on all the wells that previously tested positive, so we can get a status check on where we are.
Okay. So as far as the, so we were waiting on those results to see what's present, basically. Is that what you're saying?
We have not taken those samples yet. We're coordinating with the laboratory. We have to find the money, of course, to do the extra sampling, and we've purchased the containers, have them send the containers to us, but we are anticipating that will happen before the end of the quarter.
And which communities are served by these wells?
For the wells that we initially were above the advisory limit, those were the Tizen area, Agana, Asan, and areas of PD.
Agana, Asan, and PD?
Yes.
What about Sinahanya, Agana Heights?
For 823 and 825, the water from those wells goes down the hill and down Marine Drive. It doesn't go up the hill. So Sinahanya was not affected by those wells.
And my understanding is that you sent out advisories to these communities?
Yes, we did.
Okay.
As required and in conjunction and coordination with Guam EPA and US EPA, who helped us craft the language for those notices.
So question, so if the MCL was, let's say, down to 20, I guess it would be, I would like to know, what communities would be impacted by that if we lowered the MCLs.
We're in support of establishing the current advisory level. That doesn't change anything we're currently doing. If it was to be reduced, then we might have to reevaluate whether or not other wells needed to be provided with treatment systems. At this point, I do not suspect that any would if you lowered it to 20, but I can't be certain until we get the results of the sampling back. But if an MCL was to be established or an action level was to be established in accordance with the current health advisory level, which is by US EPA's own admission conservative and protective, we would not be doing anything differently because we're already treating to that level. We've been very proactive in our approach to dealing with this issue. If it was to go down, I could tell you that there would be cost impacts. If we did have to put in additional treatment systems, I would look at alternative options to see if we could use other means to, if other wells needed to be put online, whether we could isolate those on a transmission line and then provide a central treatment system as opposed to a distributed treatment system, one at each well site. We would look at measures like that if there were to be a reduction in the level to which we are treating. But at this point, if it was left at 70 parts per trillion in accordance with the health advisory level, we would not be doing anything differently and there would be no additional impact.
Are surface waters being tested like from Fena and Ugam?
The Fena water was tested as part of the UCMR at the point of entry into our distribution system, and there was non-detect for PFAS.
So are there plans to do further testing on those waters?
Only as part of what I previously mentioned about us doing more comprehensive testing in our system.
Can you clarify what non-detect level is?
So my understanding of the non-detect level is the level at which a analysis method cannot reliably repeat a quantitative result. So it's the lowest point at which you can get repeatable results, and if you don't get reliable, repeatable results below that level, then it's considered a non-detect. And I think currently it's 2.5 parts per trillion for the current EPA method that we're using for PFAS compounds.
Okay. And so basically, just to clarify for the public, that doesn't mean it's zero. It's just basically the level at which...
We can't detect it.
You can't. It's, right. To make that distinction, it's not zero. It's just basically what we can't reliably reproduce.
Based on the method and the science in the method.
Okay. Are there other, let's say, like areas that you plan on testing besides drinking water, let's say biosolids?
We do not have any plans for the testing of biosolids at this point. We have not been asked to test biosolids at this point. I think I may have requested our compliance and safety AGM to start looking at that, but we have not made any plans to do so.
Okay. So I've heard of practices where their drinking water has been diluted to meet the MCL levels. Is this a practice that GWA engages in?
Currently, we're not engaging in any dilution. I want to be clear. When we first coordinated with US EPA and Guam EPA in the summer of 2016 regarding the PFAS levels and when they reduced their health advisory level, that was presented to us as a potential remedy to bring the levels down below the health advisory limit. So as I mentioned, we did run a test to see if that would work with 823 and 825. It did not. The levels were too high, so we did not. We were hoping to maintain the production levels so that our pressures and our customers would not be adversely affected by pressure levels and so on and so forth. But we elected to disconnect them from the distribution system completely because we could not dilute it down.
Thank you. Have you consulted with Guam EPA regarding discharging these chemicals in the sewage system, PFAS chemicals?
No, we've not had any substantive discussions about that.
So what was the determination that was made to allow discharge from Anderson Air Force Base regarding PFAS chemicals in the sewage system in 2018?
So I'm not sure. We've received requests from Anderson Air Force Base before to discharge various things into our sewer system. And under our current protocols, we have a pretreatment requirement, and so we will review the information that for the substance that they plan to discharge and determine whether or not it will upset our treatment process based on our current permit requiremements, NPDES permit requirements at the receiving wastewater treatment plant. And if the AGM of Compliance and Safety determines in consultation with our treatment manager, wastewater treatment manager, that there will be no disruptions to the plant and we'll be able to meet our permit limits, we will allow the discharge with conditions. The most recent case, Senator, of foam that was discharged into our sewer system from Anderson Air Force Base did not contain any PFOS or PFAS. It was the alternative, the newer foam material that was being tested in one of their hangar systems, and as part of the testing procedure, they were required to dispose of this new foam that was PFAS free, and that is the most recent discharge of foam into our sewer system from Anderson.
Is the sewage system on Guam capable of handling industrial waste? Is it designed for that?
It is not designed for industrial waste to be directly discharged. We do have a requirement for pretreatment if industrial wastes are to be discharged into the sewer system, and we have requirements that we will make depending on what the proposed discharge is. We are currently developing a pretreatment program formally, which will require changes to our authorizing enabling legislation, and we have drafted those changes that we need, and as I mentioned to you in our previous meetings, Senator, we will be providing a copy of that to you once we're closer to getting it finalized.
Would you be able to develop a cost estimate should the MCL be lowered to, say, in the same ballpark as New Jersey of 14 parts per trillion? Would you be able to provide a cost estimate for testing and treatment?
The treatment, I think we can develop a cost estimate. The testing would depend on if it was established how many additional wells might be subject to the testing requirements, number one. Number two, how frequently the testing requirements would be if they're more than we're currently testing. I mean, I can give you, I have numbers based on our current operations, but if you were to reduce it, I would need some additional information in order to develop the estimates. Currently, if we were to put in a treatment system, we're estimating right now for 823 and 825, the treatment system construction would cost around $700,000 to $1 million. Operating the current treatment system we have at NAS1, we're estimating between $100,000 and $200,000 a year for the O&M for that treatment system. And these include estimates of disposal costs, which are also impacted by what potential regulations might be, so these are just estimates.
I appreciate if you can provide a report as far as the estimates for what it would take for lower MCL. What type of interagency actions have you undertaken with Department of Defense in regards to this this chemical, or these family of chemicals?
I guess the first interactions we've undertaken is when the National PFAS Summit was held, with the former US EPA administrator. I was encouraged by the administrator of Guam EPA to attend that summit with him. We both attended, and we both raised questions as to why in the report that was submitted to Congress that the DoD installations on Guam were listed as no further action required. We questioned that, and at that summit we also engaged representatives from US EPA that dealt specifically with DoD to request if there was impacts to our local drinking water system, that we be provided some assistance in dealing with it in terms of treatment costs and capital costs if treatment systems need to be put into place. We established a dialogue that continued in subsequent phone calls. We continue to have phone calls with various parties, especially in relation to NAS1, Guam EPA, US EPA, and DoD, to try and work out some solution on how we can move forward with covering those costs for treatment.
Thank you. I don't have any other questions. Do you have other questions? Sorry, Senator Shaw.
So just to follow up on that last question, what the current testing that DoD is required to do, I think it was reported earlier, they're doing testing. Are you involved in that at all?
I think we were provided the results of the testing, but we've not been involved in anything beyond being provided the results.
And what are the results? Are there any results of concern to you?
Well, establishing the source and the removal is of concern to us. We continue to provide treatment at NAS1. We've seen the levels at NAS1 drop to non-detect, and we're hopeful that if we continue the treatment and pumping at NAS1, that eventually those, this will naturally attenuate, and we won't have an issue anymore with that particular well. But outside of that, I don't have enough detailed knowledge of the results and how extensive their testing program has been to have any other concerns.
Did you say that you found the source of contamination for NAS1?
No, I said finding the source would be a concern.
That's what you want to do.
Yeah.
You haven't yet.
Similar with A23 and A25. I mean,
right.
we're doing what we can to treat the water, but until we remove the source, we will continue to have to treat the water. So if it's possible for us to put some effort into finding the source and removing it, that would help us with A23 and A25. That would, be a priority for us. It's one of the things that we've been pushing for. We know WERI has presented a proposal for a 3-year program to investigate and identify potential sources, and we're looking at how we can support that. We can provide some funding in order to do that, and I think we've got, I've made appeals to the other entities that we've been discussing this issue with to see if they could also provide some funding to support the study.
Haven't you, over the past few years, allowed additional wells to be built on Anderson Air Force Base?
We don't allow, I mean, that process, the permitting process for construction of new wells goes through Guam EPA.
Well, aren't you working with them on new wells up there? Are there new
Oh,
wells
we're-
being built up
Sorry,
there?
not in terms of production wells, but we did receive grant funding from the Department of Defense to install, to support USGS and WARI in their groundwater monitoring program of the northern Guam lands. We did receive grant funding to put in additional deep observation wells. We're in the process of getting those permitted, and construction of those will begin shortly as soon as we can get all the proper permits.
Deep observation wells, how many?
7 new wells, and we're rehabilitating 12 existing wells in their network of monitoring wells. And that's the extent of the project that we're currently undertaking using that DoD grant funding. But as part of our coordination, we've also undertaken the maintenance of all of the observation wells that are outside of the DoD fence line, and we're encouraging them, and they've agreed to take over the maintenance of the observation wells inside the fence line. I think Dr. Jensen might agree that previously there has not been a whole lot of resources put into the maintenance of those wells. We see the importance of them to the natural resource and our stewardship and management of that natural resource. And so we're undertaking the maintenance of the wells outside the fence so that we can continue and enhance the program that's already been started.
Do you receive reports on what's monitored in those wells?
We receive the information that WARI and USGS provide.
All right.
I can respond
Sure.
to that. Those
Dr.
wells
Jensen.
are, yeah, I'm John Jensen, I'm Director WARI. The purpose of those wells, the deep observation wells, is to monitor the volume of fresh water and the salinity of fresh water and its responses to natural changes in the recharge, so droughts and storms and that sort of thing. So it's basically our window into the aquifer for identifying how much water is there and what the quality is in terms of salinity. They're not there for monitoring chemical contamination. They're not routinely sampled for that. We get quarterly data. We get quarterly data on the thickness of the lens and the profile of the salinity in the lens. Recent study we just concluded that showed some interesting results.
All right. It was my understanding from earlier presentations that there is monitoring going on Anderson Air Force Base for chemicals. Are any of you privy to those?
I don't receive any, I don't believe I receive any data on that, Senator.
EPA, sorry, do you receive data on any monitoring at Anderson Air Force Base for chemicals?
Sorry, if you don't mind coming to the table so we can hear your response. Thank you so much.
The studies that the Navy are doing up at Anderson, correct. We will be receiving them. We received some of the initial data, and to be quite honest, I'm kind of shocked at it. I've actually asked Dr. Jensen what could be going on, because I do know Anderson, much like NES or Teton, has firefighter training pits that the Navy has acknowledged that they use AFFF that has PFAS and PFOA on. So when they're non-detects up at Anderson that they've presented so far, I'm skeptical of why, and I just need to look into how their sampling plan was put out.
So they're all non-detect so far?
The ones that they reported to us, correct, right now. And those were mostly their production wells. They're still going to be working on doing sampling of some of their monitoring well systems.
Wells, there are wells like at Leo Palace Is that right? Private wells?
They might be private wells, Senator, yes.
Sorry,
Yeah.
I'm
Do
not
you,
aware of any.
you don't monitor those?
No.
Do you?
We have the entity that has them monitor, and we receive results, yes.
All right. So are we aware today of all the wells that you've seen PFAS in?
So that question I can address as the production wells that we've monitored and that GWA has monitored and Navy has monitored, we got results, and we're confident, that, especially on the GWA side of where they exist. We've not done a lot of sampling at any just monitoring wells systems.
All right. Is that possible, or is it helpful?
To sample from monitoring wells? I think, not for GWA's purposes, but I think it would be helpful for purposes of identifying or investigations to support that if the monitoring wells were existing. I believe that would be helpful, but I'm kind of out of my depth on that.
Mr. Jensen, Dr. Jensen, do you still have, I know that's an arrangement that was made with your WERI and USGS, I think you said, but is it still possible to get that to be part of the arrangement, that those wells would be monitored for chemicals also?
The deep observation wells?
Yes.
They're designed for monitoring the thickness of the lens, so they go all the way down to salt water. And they're placed to monitor the effects of changes in recharge, changes in pumping. Well, so they're not optimally placed to monitor chemical contamination. Generally, monitoring well is placed for a specific purpose to monitor a specific threat that's already been identified, and they're expensive to maintain, and generally you want to put in place a well that minimizes the expense of maintaining it too. But so it wouldn't be really practical to use the deep observation wells for chemical monitoring.
All right. For how long has A23 been offline?
823 and 825 have both been offline since about August, third quarter of 2016.
And what's the earliest detection of PFAS in those wells? From this WERI report I'm reading, it looks like 2015, but do you have anything earlier?
No, 2015 is when we did the first round of sampling under the UCMR3, and that would be the earliest data that we have.
What was in the notice that was sent out? I'm just curious. You said you sent out a notice to those customers who would be receiving water from those wells.
Essentially, it was a statement that that the EPA has established a health advisory level, and that the water that they received may have exceeded that level, and it had some information on the effects and what was known at the time of the compound that was potentially in the water. So it was standard language that was provided to us by US EPA and Guam EPA, and we coordinated the language in the notice before it was sent out.
I've heard you say, either today or at the hearing we had in the session hall, that these wells have very good production levels. You'd like to get them back online if it's feasible, and then I heard you say today that you were going to do another round of testing on all the wells that had tested positive previously,
Yes.
but not on all wells on Guam, just those.
I have to balance how much extra cost that is.
Yes.
And so what seems prudent is to go back to the ones that have previously tested positive and take a look at where they are.
Okay, I'm sorry. Going back to the two wells, getting them back online.
Yes.
So WERI had proposed, potential sources of the PFAS, and And so I heard you say today that they have a plan. I think I heard them say that before, that they also have a plan. They're looking for resources from GWA. Is that what's going on? And I guess I want to know, some of these things looks like they could have been done before. What has GWA done to investigate the source of contamination for A23 and A25 and NAS1? What is the source of, do you know?
So
Yeah.
I would first like to say that I mean, I get agreement about this from anyone, but our role is primarily to make sure that we're treating the water to a safe level. And so I don't view our role as the investigative authority on this. We have an interest in finding out what the source is so that we can remove it, obviously, so that we can reduce the amount of time that we would have to treat and get rid of the source of contamination. To that end, my staff and myself, we've tried to be of assistance to both WERI and to Guam EPA in trying to come up with information about what the potential sources might be, and in consulting with Dr. Jensen, would it be feasible in terms of the hydrogeologics, whether contaminants might flow in that certain direction. So that's the extent to which we've investigated. We did receive some anecdotal accounts of a potential source for A23 and A25. That was in the 80s. Apparently there were some public outreach activities that were conducted at the Agana Shopping Center, which included the use of firefighting foam as a demonstration, I guess, during Fire Prevention Week. We heard anecdotes of that from two different sources. We then attempted to see if we could get any archived information about those events, and we did manage to obtain some photographs which show a fire prevention event at the Agana Shopping Center with a handwritten inscription on the page in a photo album that said "Treasure Hunt Through the Foam," which indicates that there would be some foam that was used at that time. And that might be a potential source, and we've presented that information, and I've advised Dr. Jensen of that. And so with the idea that in the study that has been proposed to identify the sources, this might narrow it down to an area that we could actually do some testing and get some results and facts out of that information.
Senator, if I could interject, please. So you also asked about NAS1. So there may be other potential sources, but one of the sources is, and the Navy has agreed that they are, but during their firefighting operations up at the NES, at former NES, they did use AFFF, and they did indicate it did get exposed to the environment, and that's why they've agreed that they are a responsible party for the groundwater up there.
Dr. Jensen, can I follow up with you? So in this report that was done in about 2018, I think, right? There were a couple ideas. One was to do a very quick test of the soil up at where the Korean Air flight. Had that been done?
Let me defer to my colleague, Dr. Kim, who is our PFAS expert, who has taken over the line of research that Dr. Denton did until he retired. So he is the person who is in charge of our current research program.
Thank you, Dr. Kim.
So my name is Barry Kim, assistant professor at WERI. Actually, WERI has conducted two PFAS research projects. Actually, we launched the first project in 2017 to monitor well 825 on a monthly basis to identify the relationship between rainfall event and then PFOS level. And based on this research, we found there is high correlation between high rainfall event and the higher PFOS level. So based on this preliminary result, we concluded some PFOS is impacted somewhere around well 825. So after that, we prepared another research in collaboration with the University of Rhode Island. And then after a literature review and based on hydrogeological survey around well 825, and then we selected total 22 potential PFAS contamination site. So basic approach was that in case of PFAS, what we know is usually PFAS is usually finding from firefighting training center or the PFAS manufacturing site, but we didn't find any this site in around well 825. So alternative way was to find some accident area like a Korean air crash site, and also based on literature review, we knew that there was wastewater leaking in GWA wastewater pump station near Trout River. So we defined these two sites are potential PFAS point source zones, but that was not enough. So based on other literature reviews, we also selected other non-point source zones like ponding basins and swamp river channels. So based on these ideas, we selected total 22 potential PFAS contamination sites.
Sorry, can you clarify? So you detected PFAS in sewage or?
Actually, after we collected soil and sediment samples, and we found PFAS from Trout River and one ponding basin in Haganya River, just behind the well 825. So PFAS level was around 4.5 microgram per kilogram. Kilogram means a soil weight.
All right, and the other ones that were in this report are ruled out pretty much. For example, the site of the Korean Air flight crash, the Sinahanya fire station. There was the Aganya swamp.
Yes.
Ruled out.
Sorry?
Those were ruled out as potential sources?
Well, they're not entirely ruled out. Those are hypotheses.
Hypotheses.
The places to look.
Not yet.
And, but there's a lot more looking that needs to be done. As Mr. Berdalio mentioned, you know, we don't know much about the history of the usage in these areas, and if there were releases of firefighting foam into the Aganya swamp, it's entirely feasible that these wells that are down there on the edge of that swamp could be drawing material from the Aganya swamp into their, what we call the radius of influence of the well.
Where is the A25 well located? Is this like down there? It looks like it's on Route 4 on this map.
It is on Route 4. It's at the bottom of the hill, 823, I believe.
Near
if you're
McDonald's?
driving up, just past McDonald's, if you're driving up the hill, 823 is on the left-hand side and 825 is on the right-hand side.
Okay, and then, all right, so you've confirmed the two, Trout River and right behind A25 and Ponding Basin.
Actually, I don't say we confirmed because we just took surface soil sample just one time. So that's the reason why we say it's a preliminary study. But to conclude these sites are fully contaminated, we need to conduct further investigation, taking more samples.
All right, and somebody had sent that the testing is $1,000 at a shot. What kind of testing and what kind of prices are we looking
there is some story. So far, where we spent around $130,000 for these two researches. But So our main problem is we don't have the instrument that we call liquid chromatography mass spectrometry, we call as mass spec. Usually the people's analysis cost is about $500 per sample. So it costs very high. So although we have around $100,000 research fund, so far we only analyzed around 50 samples because of limited funding. So that's the main difficulty nowadays.
Okay. All right, I appreciate your answers. Thank you very much. Wait, I'm sorry, Walter, did you have no, I'm sorry. You confirmed about NAS1, and WERI, just to confirm, is not doing any research in regards to NAS1.
So as I mentioned before, that's because of limited funding.
Right.
Yeah.
You're concentrating.
So, yeah, the reason why we focused on well 825 is well 825 is the most contaminated well.
Okay, thank you. And GWA, is there an observational well on Tizen?
I'm not certain. I'm not certain of that, Senator.
There are monitoring well systems, one specifically for the dump site that exists up there, and the other just to continue to look at the groundwater for the previous TCPC contamination that was existing there.
Can we add PFAS testing to that then, if you're already testing there?
That's in the works.
All right, thank you very much.
Okay, so I think, yeah, Senator Chalabi asked a lot of the questions I think that I wanted to actually follow through with the studies, and it seems like you did cover. Is there anything that we didn't cover as far as your studies and your proposal to do more testing?
So Guam EPA with their contractor, we currently, and this is the work plan wasn't passed through GWA, but we got their concurrence to do it. But we're looking at some of their sludge to see what exists. We're doing a compost pilot project that would include sewage sludge, and it was we determined that we needed to ensure before we even allow anybody to think that this is an allowable practice, that we better make sure the sludge is at least acceptable. So we did test for metals and PFAS in it, and we can give you the data on that when we get it better. Yes.
Okay, thank you so much. So actually, I have a couple questions for WERI. So thank you, GWA and Guam EPA for coming back. So what are the challenges of identifying the source of PFAS? I mean, knowing what you know about the hydrogeology of Guam and the properties of these chemicals being mobile, what are the challenges in identifying the sources?
Well, it's a process of elimination. For any given place where you find it, there could be any number of places upstream where the groundwater is flowing from, where a given contaminant could enter the system. So you have to look at all of those. But a more fundamental question is how to identify the footprint of the material as it's traveling through or where it's starting out in the system. And I'll defer to Dr. Kim to kind of give you a little summary of the work that he's doing now. He has a student working on a project related to this, and I'll let him explain some of the details of that.
So actually, where we approach research based on fact. So that means, so the reason why we have focused on PFAS contaminated well, mostly well 825, is because we have data from US EPA. But if we can get more information, for example, firefighting stations if they use firefighting foam, and then if there is some data, then we can easily access to find a potential contamination site. But so as I say, so based on fact, what we found from literature review and then open data, so we established research.
You're talking about footprint. So let's say, it's been released. So let's just talk about the different sub-basins within the aquifer. So if you're talking about the Agania Swamp, what is that? What is the boundaries of that sub-basin?
We brought a map. We could break that out and show you. Yeah, they're basically six. You want to get the map? The six sub-basins, the six basins in the aquifer are separate watersheds. So, for instance, the flow in the Upi Basin, where the Air Force Base resides, is entirely independent from the flow down south in the Agania Basin. Actually, the Agania Basin, we're thinking of dividing into two separate basins because some of the water goes to the Pacific side and the other water goes to the Philippine Sea side. But the boundaries of the basins are the heavy blue lines there. So you can think of those, as I mentioned, just like the Talafofo watershed in the south is different from the Ilig watershed. The water doesn't cross over from one to the other. That's pretty much the case of these groundwater basins.
Specifically about the A23, A25 wells, we're focusing on the Agania Basin, sub-basin area, right? So what is the high point in that watershed, or sub-watershed, I should say? So do we need to... Sorry, do you mind if we just take a brief recess so we can set up the map? And it gives us time to have a break too, as well. Thank you.